Thanks. Be seated.
Thank you, everyone. You can be seated.
Ron,
Yes.
before we get started, just so I finally understood what the court said. After Mr. Rosenwasser's closing, we're going to break and go over jury instructions. There's also the issue with the evidence, the laptops that are going back.
Right.
Look at those. So, okay.
Right.
I just wanted to make sure I understood.
Hopefully it won't take too long because we've already done most, but yeah, we'll have to do that.
Detective Smith is out, will be outside.
Okay.
We'll have bolts, everything ready to go, so as soon as you're done,
Okay.
they're out. They can look at whatever they want.
Awesome.
He'll be staged outside.
All right.
It's all done and ready to go.
And just in case I don't remember, we still got a court exhibit thing issue. I don't know if the state, somebody's video that was used, we were going to get a thumb drive and put that in as a court exhibit during openings. Remember that? I had it in my notes.
That must have been the defense.
Was that the Transcend?
I don't know.
We'll figure it out.
Okay. Because that has not come in.
Okay.
And there was something else that was a court exhibit. But, huh? You didn't? Okay, then it had to be you guys. Let's see.
We'll make sure that we look at the notes,
Yeah, we'll make sure we get all that in.
Serena's been taking notes about the whole thing for us.
The good news is it is a court, every question I had was about a court exhibit, so they don't go back anyways, so. Huh?
I show it was during the defense.
Okay.
opening.
So whatever that was, all right, if still requested. I mean, I don't know that it's, I don't know. Anything else?
Nothing to say.
All right, we'll bring them in. You're using this then? Okay, I'll have to relook. Kate.
Your monitor works.
Oh, okay, and I can see all the jurors.
Right, your monitor works, don't touch nothing. I got it working.
Thanks. Thanks. Tricia's on standby just in case. Okay, yeah, you can bring them in. Yeah, that'll work fine because I'll be able to see them and I can see them.
And they'll be up on the big board.
Cool.
Sorry.
All right. You're good. You're right. I'm still not as bad as Judge Tepper always was. Oh my gosh, you would start pushing buttons before anything would even happen. She'd push another button and it's like, whoa, stop.
Here we enter the courtroom, Your Honor.
Okay.
Jurors may be seated. I'll do present and accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess? All right, we're going to get started again. As I indicated at some point, I don't know if it was yesterday or this morning, but I told you the order of things. Mr. Rosenwasser will now get his rebuttal closing. After that, we'll take a little break, and then we'll be giving you your final instructions. So we're getting there.
This will not be long. At the beginning of the case, in opening arguments, and also during jury selection, we had a conversation about sympathy. So it's important to remind you all about sympathy as we get to the very end of the trial. Now, as you all know, sympathy should never play a part in the justice system. It wouldn't be fair to anybody. We would not want you to find the defendant guilty because you felt bad for the Olsen family. Wouldn't be fair. But in the same vein, we don't want you to find someone not guilty because if for any reason you feel bad for the Reeves family. Now, sympathy, of course, is a human emotion, but it really does have no part in the criminal justice system. In fact, there's an instruction that Judge Barkle is going to read to you, and I'm just going to read it to you very quickly just to show you that it's in there. It says, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. So I know it goes without saying, and I almost feel bad saying it, I know that you won't let sympathy affect the verdict. You also know that the judge is responsible for any sentencing. You should not let that factor into your deliberations at all. You are the fact finders and the law appliers. Any sentencing issue is for the judge. Now, sometimes in trials what happens is this. Sometimes when you walk back in, and I know this might sound silly, but sometimes when you walk back in, someone might be in the audience. Might be a family member, might be a friend of either side. They might give you a smile or a glance, or sometimes people look away. Obviously, that does not have any impact on your deliberation. If any of us looked over and smiled, or at some point we looked like we weren't happy, the same for the defense table, has no bearing on the case. It would kind of be like putting it into the shiny object portion. It really doesn't mean anything at all in this particular case. So it's just very important for you to remember that. There were some comments that were made during defense counsel's closing that I do want to address. And then afterwards, we're going to fairly quickly just go through some things on the video, and I'm going to sit down. A couple very minor points, quickly address them. Defense counsel in his closing argument talked about DNA, how the defendant here could not be excluded. Well, there was a stipulation that was read, and really what the stipulation said, one part of it was there was not enough DNA on the phone to determine anything. Couldn't be included, couldn't be excluded, didn't mean anything. There just wasn't enough DNA on there. Doesn't really matter, because we all know based on the evidence, this phone was never thrown. The reason that the phone was where it was because either of two things happened, and no one knows. But the reasonable inference from the evidence is that when he reached over for the popcorn, it fell, or at the time he was shot, it fell. We know for a fact, though, with 100% certainty, that at no time was that phone ever used as a weapon, wasn't used to punch the defendant, and certainly was never thrown at the defendant. We know that for a fact because why? Because there's absolutely no injury. And even if that was some miracle, there's not a single person that saw an attack with a phone in the entire case, including his wife. We know with 100% certainty there was no phone at issue. The reason it's on the ground is because it was dropped at some point in time. That's it. There was another mention in closing argument from defense counsel about how if you have a phone, you have this phone, it should be placed into airplane mode. Here's when that's important. If a phone is being searched for videos or for photos or for text messages, the content, you can save the content by putting the phone in airplane mode, or you put it into a certain box. If you're going to be looking at it for DNA, which in this case doesn't matter because it's just a shiny object, but if you were looking at it for DNA, you don't care if the phone's on or off. That's just a shiny object. Doesn't mean a single thing. Defense counsel talked about the timing of certain things, and we'll go through it on the video. But he mentioned that Nicole Olson stood up, and prior to the popcorn being thrown, she had her hand on Chad Olson and she was holding him back. Well, how do we know that's not true, that that's not the proper timing in this case? Number one, it's not on video. Number two, we go back to this point about eyewitnesses. Not a single person testified that there was a struggle where Nicole Olson was trying to hold back a charging Chad Olson. Who didn't see that? There's nobody in the entire case that saw that happening. And if it happened right in front of who? Vivian Reeves, Jane Roy. Nobody saw that. Why? Because that never, ever happened. You keep going back to the defendant starting it and the defendant ending it and a popcorn toss. And that really is this case, unfortunately, in the most simplest of terms. That's just what happened. It's sad, but that's exactly what happened. Defense counsel brought up, and it's kind of the reason why I brought sympathy up with you, all these things that the defendant had done. But it almost seems like the argument is this. Because in his past, he did these things, you know what? We shouldn't be having a trial. We shouldn't have you here as jurors to even discuss the fact that Chad Olson was unlawfully killed. He's excused from killing someone based on his background, training, and experience. And if you think about that, it's really an unbelievable argument. Now, in theory, we have laws in the United States that apply to every single person, in theory. From the President of the United States all the way down to Pasco County, every single one of us is bound by the same laws. You can't unlawfully kill somebody. It doesn't matter if you're the head of security at some point in your life of Busch Gardens. It doesn't matter if you're a police officer. It doesn't matter if you're a police officer today. Police officers are not given free passes. Nobody is ever above the law. Ever. You never start out one step ahead. Ever. It's as if to say, you know what? Chad Olson's life was meaningless because he graduated summa cum laude. Chad Olson's life is meaningless because he started the SWAT team that they use today. Chad Olson's life is meaningless because of the things he did at the Tampa Police Department. His life is meaningless. We shouldn't be here. That's sort of what's being said. Nobody ever starts above the law. Ever. Doesn't matter who you are. Doesn't matter what job you have. It doesn't matter how much money you make. We're all judged equally under the law, no matter what. He killed another human being in a crowded movie theater next to his wife for no reason. Nobody should care what he did in his past. It's what he did on January 13th of 2014. He killed another man in a movie theater. Defense counsel talked about this first attack happening so quickly. It happened so quickly, he didn't even mention it to Detective Proctor, right? It's because it never happened. There was a conversation about Detective Proctor making a mistake because he never, ever had investigated a self-defense case. And I mean this as almost sarcastically as I'm going to say it. If he never investigated another case after that, he still has never investigated a self-defense case, because this is not a self-defense case. We're going to quickly go through the video. It's kind of like the cross-examination with the defendant.
May I just dim the lights for this?
Sure.
And when you get the computers, if you get the computers in the back, the MOV files are the ones you can open with QuickTime. Of course. Take one.
Yep.
Go. There you go. Got the magic finger apparently. Everybody see this one? here's the beginning where we were talking about the reflection. The reflection being the shoe. At no time was the reflection ever the cell phone. It has always been the shoe. It's not a coincidence. This is the very first frame where you can see the defendant's shoe as he's walking. It's going to go back and forth. Always motion. That's the shoe. Now, defense counsel talked about all these experts they were trying to get and all the money they were spending. They save a lot of money just by looking at the video because it's very obvious that it was the shoe. What's the importance of this? The importance of this is the defendant and his wife coming into the theater. And it's really nothing in that they're just walking in the theater, but the camera's able to pick them up because it's within the motion sensor area. Okay? That's the importance of just watching the very beginning. An almost insignificant event of two people sitting down triggers the motion-activated camera. Now, when you're looking at this, if you can look, you see the defendant is on the left side, and this is Vivian Reeves on the right side. In front of Curtis Reeves, you can see this is Nicole Olson. So they sit down, Nicole Olson is already there. Here's the next time we see the shoe. He's crossing his right leg over his left leg. There's the shoe. Okay? We don't have multiple cell phones. Nothing's happening. This is obviously his shoe. No speculation whatsoever that a phone was ever in play. Here he is leaning all the way in. Back appears to be fine there. Getting up to go to the manager. Now, for the next 3 minutes, he's at the manager's desk. He's returning back. Lo and behold, legs moving, there's a flash of light. No cell phone being thrown there, flash of light. Again, we don't need an expert to tell us that. Once the defendant comes back into the theater, as Derek Friedhoff indicates, once again there's bickering. Chad Olson turns around in his seat. Coincidence? The defendant's right leg is moving. As he moves forward, you see the light. Absolutely, with 100% certainty, his shoes. And as we indicated, there is absolutely no way at this moment that a phone is being thrown as he goes forward. And his explanation for not reacting, not putting his hands up to his head, not exclaiming anything, not having any injuries was because he took karate some time ago. Now, what did the defendant indicate? Now remember, there's this first attack. There is no first attack. However, what the defendant indicated is that during this blue screen time, and remember we had a conversation up here, he's like, well, the camera doesn't hit row B. This camera is not picking anything up at all because there's not any type of significant event that is being recorded. So when the defendant wants you to believe that during this period of non-recording, Nicole Olson is fighting back with Chad, who's a raging lunatic, it's not picked up by the video because it's not happened, because there was no phone thrown. It's an absolutely made-up event that didn't take place. Now, the other important part of this, I'll tell you in a second. So now he's reaching over, he throws the popcorn. The popcorn has now hit him. After the popcorn has hit him, the defendant is going forward. Now there's another flash down here, which is obviously his shoe. He has been hit with the popcorn, the gun's at the hip, he reaches forward, and he shoots him. Popcorn, thrusts forward and shoots. Now, Roy Bedard. Let's talk about Roy Bedard real quick. Roy Bedard did testify 2 years ago in a case that I prosecuted. And what Roy Bedard does is he travels around the country, testifies for the state, testifies for the defense, and he educates juries on self-defense. Now, the unlogical or the illogical leap is that because Roy Bedard didn't testify for the state in this case, that means the defendant's not guilty. That's the extremely illogical leap. Because if you took that position, anytime somehow Roy Bedard becomes the person that is critical for any case. So for the rest of my entire career as a prosecutor, if Roy Bedard on the other side, that means that person's not guilty. That's how illogical that argument is. Now, we know, based on the evidence, that this was, unfortunately, about popcorn because of the defendant's statement. But for just a second, let's suspend the reality, because that's what the defense wants you to do, is suspend the reality that it was about the popcorn, and that it wasn't. What that means is, if you want to believe what Roy Bedard stated, and he wasn't asked, who knows if he knows anything about the defendant's statement about popcorn hitting him? We don't know, no one asked that question. We don't know where that information came from that he testified to. But let's just suspend reality because we know the defendant made that statement. If he started the process of shooting and killing Chad Olson, think about this. It's worse for him. Because what's happening right here? There's not a single thing that's happening here. So he made the decision to kill him for absolutely no reason. But in reality, that's not true. You have to suspend the reality. Because what happened was, after the shot, he made it clear why he did it. He had an explosive moment of anger. He was angry because of what happened with Chad. Because Chad was standing up for himself, was saying things about texting his daughter. He reached over, he grabbed the popcorn, and he threw it on him. And when he had his hand coming back, that's when he was shot. He was not about to attack him. There wasn't any imminent threat of death to the defendant. Wasn't any imminent threat of great bodily harm. I'm not going to go through all the jury instructions with you. That is this case. That is really this case. That's the end of it. There was a question asked by defense counsel of Detective Proctor. There's a series of questions. And when I heard them, I thought, that was a really great set of questions, but not for Detective Proctor. And I wrote them down, so I'm going to give you a version of it. If it's not exact, it's not exact. But it was a really good set of questions. But when I say them, I want you to think about it from the defendant's point of view, not from Detective Proctor's point of view. And this is what the questions were. Is it important to be right and accurate in a homicide? Dealing in possibilities is dangerous in criminal court because a man's life is in your hands. I mean, that's really powerful. And that's exactly what was at issue in this particular case. The defendant here had a man's life in his hands in a movie theater on January 13th of 2014. Chad Olson went to the movies and he never came out of that movie theater. His life was taken from him. It was an unjust shooting. He didn't deserve it. Not under that fact pattern in that theater on that day. We come back full circle. The defendant started it. The defendant ended it. And yes, unfortunately, a man was killed because popcorn was tossed. The defendant is guilty of either murder in the second degree or manslaughter. And he is guilty of aggravated battery as well. Thank you.
Thank you, Mr. Rosenwasser. Yeah, just push it back. That's fine. Great. All right, ladies and gentlemen, I know that was pretty quick. I do want to, I got to let you go for a short break. The lawyers and myself have a little bit more work to go over shortly before we begin your instructions, okay? So go ahead and take about probably 15 minutes, maybe a little longer, but Deputy Martin will come and get you when we're ready. Probably at least 15 minutes, and then we'll be ready to start with instructions, okay? Remember my instructions during the recess. All right, thank you.
All rise for the recess of the jurors for 15 minutes.
Good afternoon, folks. JB Buno here with you live on WFLA Now, a live look at Curtis Reeves on trial for second-degree murder in the 2014 shooting death of Chad Olson. Final arguments now completed. You have heard from the prosecution, you've heard from the defense. We're about to break it down.
Yeah, if you, it doesn't matter. Well, I can't see, I can't see the defense, so, yeah, if you could go ahead. Go ahead,
Good afternoon, everybody. JB here with you live across all of our social media platforms, as well as on WFLA.com, the WFLA app. Curtis Reeves, his fate soon to be in the hands of the jury. After this 15-minute recess, the judge is expected to be giving the instructions for jury deliberations to begin. How long those deliberations go on for is really anyone's guess. We do not know if it's going to be a relatively brief deliberation process or whether it's going to be an extended deliberation process. It really comes down to just how much in unison the jurors are in the facts of the case and their interpretation of whether or not we have a guilty verdict. So that's all coming up here, folks, in the hours ahead, and we're going to stay here with you live on WFLA Now in what we expect to be extended coverage of the Curtis Reeves trial. They are not expected to go home at 5 o'clock Eastern time, as they have, or around that time, and in previous days over the last 2 weeks. This is expected to be an extended session of deliberation. in the hopes of getting a verdict in before the weekend arrives. Now, you can't rush deliberations. Deliberations are, of course, extraordinarily key when you're talking about a trial of this magnitude. And this is 8 years now in the making. You have to remember this shooting death occurred in 2014, 8+ years ago. So the deliberations are going to take however long the deliberations are going to take. And then we're going to have, of course, the verdict to be read aloud here in court, and whether or not Curtis Reeves is going to be found guilty of second-degree murder. Just want to let you know, we're live on Facebook. We're also live on YouTube. I see a lot of folks joining us on YouTube. I have the comment sections for both pulled up here on our screens, and I'll be paying attention to some of the questions that you have to say. You can use hashtag HeyJB to interact with me here, and I can try to feature some of your comments on your screens. What are we looking at right now? We're looking at them just making some, just basically crossing some T's, dotting some I's with the final sort of stage of this process, with the closing arguments portion of the trial now wrapping up and moving into jury deliberations. So that's expected to begin in 15 minutes. And over these next 15 minutes, I'll do my very best to answer some of the questions that we have across our Facebook Live and YouTube Live comment section. So let's go back over to Facebook if we can. And I'll take this one in the meantime. Ned Kelly on YouTube. Hello to you, Ned, saying hashtag HeyJB. Why has this case taken so long to come to trial when this happened 8 years ago? And says hello from London, England. Hello to everybody joining us from the UK. I know a lot of folks in our YouTube comment section join us from across the pond over there in the United Kingdom. So the reason is multifaceted, but it really comes down to primarily this whether or not this was going to be classified as a stand-your-ground case. The case itself, the Curtis Reeves case, went as far up the ladder as the Florida State Supreme Court, and the Supreme Court ruling, and it was eventually ruled that it was not a stand-your-ground case, the stand-your-ground law here in Florida, and then of course the pandemic rolled around, and the pandemic just muddling the legal process and the backlog of cases that had to be tried in a court of law. There's just been several different reasons as to the extensive delays that we've had here. They have not given jury instructions yet. No, they have not. We're just kind of communicating here in our newsroom. So the jury instructions are going to begin right after this 15-minute recess, and they're going to be given very specific directions as to what the process looks like as far as determining what the verdict is, the jury's verdict. Let's go to a couple of the comments on Facebook Live. Doreen McDonald. Let's see, Doreen, we're going to try to bring in your comment interactively if we can. Just give me a second and we'll be able to load those comments in. And again, you can, if you don't want your comment to be featured, just don't use hashtag HeyJB and we'll let your comment kind of scroll on by. But if you do use hashtag HeyJB, we can feature your comments interactively here on WFLA Now. We'll try to go back to the comment that I just had in the queue, including here from Doreen. First, real quick, Lisa, we just answered Lisa's question, hashtag HeyJB, why has it taken so many years to have this trial? We just went over that. And then Doreen, hello to you, Doreen. Hope you're having a good day. Hashtag HeyJB, how can it be self-defense if, one, Reeves was the person making all contact, and two, it's already been ruled out not a stand-your-ground self-defense. Just because it wasn't determined to fall under stand your ground doesn't mean that the defense can't argue that this was a case of self-defense here in the state of Florida. But let's just talk about it, because you're saying Reeves was the person making all the contact. And I think what Doreen means by this is that there were 3 interactions that occurred between Reeves and between Olson. There were the first 2. Again, this is all over texting. For those who might be new to this trial, this is all over texting in the movie theater. We had Curtis Reeves and his wife seated in the back row of the movie theater, right behind Chad Olson and his wife, Nicole, who you've been seeing in a lot of cutaway shots with the blonde hair in the courtroom. And Chad Olson was seated ahead of Curtis, and Curtis made the first two interactions, in essence saying, please, turn off your cell phone. Turn off your cell phone. Did you see the disclaimer? The movie theater has, of course, rules. Do not have your electronic device on, so on and so forth. By now, everybody knows you are told in a movie theater repeatedly to not have your phones on. And Curtis Reeves had noticed that there was a light from Chad Olson's phone, the same light that you have just that your phone screen emits, was shining in his face. And he was seated almost directly behind Chad Olson. And so there were two exchanges, each exchange getting a little bit more contentious. After the second exchange, Curtis Reeves goes and contacts the manager, comes back. Then there was a third time initiated contact, which is when things escalated significantly. Now, the big question in this case is what happened in that third altercation right before, in the seconds before, Curtis Reeves shot and killed Chad Olson. Let's make no mistake about it. No one is arguing the fact of the case that Curtis Reeves pulled out his handgun and shot Chad Olson, and that was a fatal gunshot wound that led to Olson dying at the age of 43. That's not being disputed in this case. What is being disputed is what led up to that in the seconds beforehand. Now, Curtis Reeves took the stand and said that there were two moments of attack that occurred where he felt that he was attacked and was subsequently felt that his life was in danger. The first time is the one that everyone's paying the most attention to, and that is whether or not there was either a fist thrown or a cell phone that was thrown in the direction of Curtis Reeves, or whether or not Curtis Reeves was hit with a cell phone. There is, on the surveillance footage that we've been seeing, there is that flash that goes across the screen, and I want to make this very, very clear because this is super important, folks. That flash, and interpreting what that flash is monumental in this case, because the defense is arguing that Reeves was attacked with this phone and then was acting in self-defense when he shot and killed Reeves. The prosecution is arguing that that reflection of light seen in the surveillance footage is reflective material on Reeves' sneaker and not a phone, and that there was no witness account of any kind mentioned in this trial that anybody saw a phone striking Mr. Reeves at any point in the movie theater. So this is a major, major, major point for the jury to consider as to whether or not they think that the reflection seen in the footage is the cell phone or whether or not it's the reflective material on the sneaker. The sneaker has been brought out multiple times and showcased in the trial itself. So to Doreen's question, how can it be self-defense? The defense is arguing that it is self-defense because of this perceived strike of a cell phone or Reeves being hit with a cell phone from Chad Olson in this incident that took place in this Wesley Chapel movie theater 8 years ago. There's also been some inconsistencies in statements given by Mr. Reeves as far as the statement that he gave around, in the aftermath of the shooting, and the statement that he gave yesterday when he took the stand in his own defense. That too has been very much discussed in closing arguments today, and it's really just going to come down to whether or not whether or not they believe that Curtis Reeves was acting in self-defense. There's also been this notion put forth that Chad Olson was coming over the rows of chairs, but as you heard in closing arguments there, they have said that the video evidence doesn't support that, as well as witness testimony doesn't support there being this coming over the row of movie theater chairs in the direction of Curtis Reeves. So Curtis Reeves says he feels that he was in fear for his life. He was in fear for his own safety, and he was acting in his own self-defense. And the defense is arguing that this is somebody who has extensive, lengthy I'll say an impressive resume when it comes to his career with Tampa law enforcement. This is somebody who was tasked with the conception of putting together, in essence, the SWAT team for Tampa police decades ago. Somebody who has worked in detective work. He's worked in so many different departments in law enforcement before transitioning his career into security over with Busch Gardens. He's a decorated Tampa Bay law enforcement veteran, a retiree of Tampa law enforcement, and over the course of his career, he's never discharged his firearm once. That's what they have said repeatedly in this trial, that he had never had to use his firearm in the line of duty. He did in this case, and the defense is arguing that he would not have used the handgun had it not been for somebody with such expertise in training other officers on how to handle and diffuse situations like this, had it not been for the fact that he felt that he was in a life-threatening situation. So you have the two sides here, and it's really going to come down to, of course, who has it really comes down to, more than anything, the interpretation of the law. It comes down to the application of the charges to this particular case, and what the jurors determined to be the charge that they find applicable, if there's any charge that they find to be applicable in this case, as far as finding Reeves guilty, or will they exonerate him? We will see. Go through a few more comments. Again, use hashtag KJB. Even if it's not a question, if you just want to have your voice heard, that's the whole purpose of us using the hashtag system, is so that you can have your voice heard. So if you want to share, some backstory on the Curtis Reeves case, perhaps you've been following this for 8 years. This is something that you have something to say. You can use hashtag KJB, and we'll try to feature as many comments as we can. It was brought up. I'm going to try to, let's see, can I bring up this comment from, I think I can. Hold on. It comes from Kathy Irish. Yeah, let's bring up Kathy's comment. This is I know that it sounds so simple, right? Someone's bothering you in a movie theater. You want to get away from them. Just move away. Kathy Irish says, hashtag AJB, why didn't Reeves and his wife just move over to other seats? Simple fix. He said, Curtis Reeves was asked that question on the stand, and he said to the effect of, he didn't feel that there was any danger or any problem at the time. He just wanted the person in front of him to follow the rules of the theater and put away his phone. He didn't think of it as much more than that at the time, despite it being such an obvious solution, right? Just move your seat and move over. But Curtis Reeves didn't want to, or didn't think to, move to a different seat. He and his wife were waiting for his son who did arrive just about at the moment of the shooting itself. They were all meeting at the movie theater, a Monday matinee of the Mark Wahlberg film Lone Survivor. Yes, that's how long ago this was, 8 years ago in 2014 when that movie was in theaters. And I believe that we have some audio coming in here. Let's just listen in for a second. Okay, there was some stray audio that came in for a second. I didn't know if they were preparing for additional conversation between attorneys in this case. Doreen, I'm going to throw your comment back up here in a second. I see you have a follow-up comment. I also want to get Deanie Mac's comment from YouTube on here as well. There's a good amount of questions coming in. Let's go back to I want to wrap up with with Doreen because she's following up. And she says, hashtag HeyJB. Oh, some more
All
straight
right, counsel,
Hold on,
I
we'll
have
come back.
in my hands what I believe to be the final version of the instructions. I want to go through them. I'm not going to read them line for line. I'll do that in a few minutes when the jury's here. But I'm going to reference each page according to what it is, and I'm going to be looking at the page. I haven't seen any typos or issues or problems, but let's go through them one more time. Make sure that we're all have the same order. All right. So I'm going to start with the first page is Introduction to Final Instructions, one sentence instruction. Same with Statement of Charge. We've got murder in the second degree and aggravated battery. Third page is Intro to Homicide. We got second degree murder at the top, and then all of that. Is there any questions about the body of that?
None from the state.
We don't have any.
Okay. So that leads into the murder in the second degree instruction.
No objection from the state.
None from the defense, Your Honor.
Okay, that looks good, that one. I don't see anything there. And that is followed by possession of a firearm and discharge. That's got all of the language in there. Okay, so then we go to the lesser 3.4 lessers, and the lesser indicated is in murder in the second degree is manslaughter.
And I just thought of a page that we don't have.
What?
I don't think we have, after aggravated battery, the lesser page that says the lessers of
Oh,
aggravated battery,
okay.
felony battery, and battery.
I knew, that's been nagging at me, you're right. I knew there was another lesser somewhere of this one. Okay, so that's 3.4, and we've got,
So we'll have to have someone make that one up.
yeah, we'll need that. All right, so that's going to go after the aggravated battery anyway. So manslaughter, that's followed by the manslaughter instruction, which is 2021 version.
No objection.
Good on that one? All right, and that is followed by aggravation of a felony with a firearm.
No objection from the defense, Your
No objection.
Okay. Then we have justifiable use of deadly force. And you guys have all gone over that extensively, I know.
Correct. State has no objection to this.
Honor.
Okay.
Your Honor.
All right, the next one is battery, bat 65. And that looks, no objections on that one.
Correct.
No, Your Honor.
All right, and then we've got the aggravated battery, the, of Chad.
That's Nicole Olson.
The one that I have is,
Oh, you weren't on the...
It's of Chad, it's part of the justifiable.
Right.
Right. I thought we were there. Okay, so bat 65, then that aggravated battery.
Right.
Okay.
and then the, another ag bat with Nicole.
Yes.
Correct.
Okay. And yeah, we need the lessers.
After that aggravated battery is the possession of firearm and discharge causing great bodily harm or death.
Okay, okay, so that sticks with the ag bat.
Then after that, we need the lesser.
Then after that is the lesser.
Mr. Funderburg, I think, is doing that right now.
Okay. So that'll be felony battery and battery. Correct, okay. So we have both of those. We just need the lesser. Any problem with the felony battery or the battery?
No, Your Honor.
All right.
No, Your Honor.
Then comes the transferred intent, and you both worked on that one, so it's, should be good.
Yes, Judge.
All right. Then plea of not guilty. That shouldn't have had any changes to it. It all looks good.
We added shall, we all agreed on.
Oh,
that.
that's right, yeah.
That's in the instruction.
Yeah, correct. All right, and weighing the evidence, looks like we've got a total of 6 there. That all looks appropriate.
We had no objection to the 6. I don't think the defense did. We
Yeah, we talked about
We
those.
discussed those yesterday.
We've got number, quality, then law enforcement witness, expert witness, defendant witness, proper to talk to lawyer, and then your own conclusion. All right. Defendant's statements is in there.
In my copy, I don't know what the court has. I have him and her.
I do too. Anybody worried about that?
I'm not. If we wanted to make it perfect, we would take out the her, of course.
Right. And take out the brackets.
Yeah, well, let's do that.
Okay.
I'll give it Mr. Funder.
Okay. Rules for deliberation. You know, we could really take out, well, just leave it, number 7.
Yeah, we could take that. I mean, no one would probably think about it because it didn't happen.
Right, but,
It would be better to take it out, I think.
yeah,
Well, but I don't know
Yeah.
if that's part of their note-taking, not, I understand I know what it means legally, but, I would just, there's no harm in leaving it in.
I don't see any harm in leaving it.
I don't either.
Okay, I'm good with it. And then there's not much you can talk about on the cautionary instruction. Single defendant, multiple counts. Would that, it doesn't matter. I was gonna say that might do better in front of the cautionary instruction, but,
I don't know where it goes in the book. Wherever the order is in the book
yeah,
is where it should
I
go.
know.
Well, let me read the book.
I think it goes before the cautionary. Usually the cautionary and those are the last 2, but I may be wrong.
Well, Your Honor, on single count, now that I look at it,
Mhm.
because this is an issue of transfer intent, and then transfer intent, which cuts the other way, if it's justifiable, the use of force,
Mhm.
must find Mr. Reeves not guilty on the count involving Mrs. Olson. The last line in single defendant, multiple counts says the finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. So, I mean, that seems to imply, if somebody reads this, that there may be a conflict in getting the instruction that.
Yeah, the transferred intent.
Yes, Judge.
I don't think so.
Well,
Only because, let's just say hypothetically that they were going to go guilty on one. Then they could say
Yeah.
not guilty on the aggravated battery.
Right.
And if it does come back, then we know we just have a legally inconsistent
Right,
verdict, and then you know what you have.
right.
There's no
I
argument
think the only other option I would think, you'd almost have to say unless you find that transferred intent applies,
there.
but,
Then it gets,
right, that's getting, I'm okay with leaving it just as it is. And if there's an inconsistent verdict,
legally inconsistent.
so
it'll be adjusted accordingly.
I understand we're requesting that that line be struck. I understand the court's ruling, but that's what we're requesting. Certainly, if it ends applicable to it, must be considered separately and a separate verdict returned as to each. So I think that says it. I think, without putting the language of transferred intent, since we already have that instruction, that last sentence, if that's struck, that cures it.
Yeah, but, I mean, just think though, that if that would totally not apply if they found, well, I don't know. You know, they could find
Well,
not
then that-
guilty as to,
Right, that's the issue. They, you know, let's say they check, let's just say they find the second degree murder was justifiable. Then they're going to find, or make a finding that Mr. Reeves is guilty, but for some other reason other than transfer to 10. I mean, I don't know.
Well, then it would be a legally inconsistent word,
Right.
so we couldn't do it.
I
right,
understand.
right. That's
It's correctable.
uncontroverted.
Okay.
If that's how it, if they find it to be justifiable, then they can't find guilty on the ag bat.
I know.
So,
Okay.
That's on the
That's our
record.
objection.
Okay, I get it. I think if we change this one, we're asking for a lot of confusion. And I know that's not typically a reason not to, but I think it's a pretty good reason not to, with the understanding that we have a perfectly lawful remedy should that
Immediate
situation arise. All right, so anybody find where they're at? Should the cautionary instruction
I'm
be?
looking now.
I don't think it really matters, but it just, I don't know, I seem to think it, remember it going before the submitting.
Right, because submitting is in closing, so definitely before that one.
Oh, yeah, but it seems like that's the one that goes before. I don't know, what I'm saying is, I don't know if it goes before the single defendant, it just seems to flow better with the
After.
final, yeah,
Right,
It goes after, I found it.
okay, good.
Right
After the
before.
questionnaire instruction, that's when you go through the verdict form.
Oh, it doesn't say that on there. Oh, I would have been lost on that.
You know
Where?
what? We're missing that page.
Yeah, where is that?
3.12, we're missing that whole page.
What page
Okay.
is that?
3.12,
What is that?
verdict. And the judge reads how the verdict form goes.
Yeah,
Must have left that out of the package.
Yeah, we need that whole one.
yeah, I would have been lost there for a minute. Because it says read verdict now. Read verdict form.
Yeah, so we need that page, and then the verdict form we all have agreed on.
Okay.
And after that, goes single defendant, multiple counts,
Yes.
and then submit a case to the jury.
Okay.
So we have, what, maybe 3 pages we need to correct?
All right, so we got that one instruction needs to go in there. Is it just 3? We have we're not doing anything with that single defendant, multiple counts. We need the lessers for ag bat, and what else?
Page we're missing about reading the verdict.
Right, that's 2.
We're taking out the her.
Oh, that's right, thank you. All right, and who's got these on their computer?
I think Mr. Thunderberg is doing some of them, right?
Okay.
Yeah, we can, Judge Weil, we can make a very quick motion that we're going to make as well. It's we're going to renew our motion for judgment of acquittal.
Okay,
Same arguments that the government has failed at this point to present any evidence whatsoever to refute the justifiable use of deadly force in this case for Mr. Reeves.
all right.
And specifically with the instructions that everybody has approved, they have failed to meet that burden.
Any response?
At this stage, the court has heard all the evidence. There's ample evidence to support this case being submitted to the jury. We have proven all the elements for second-degree murder. We've had witnesses that have indicated that the defendant appeared grumpy. We have sufficient evidence that there is a significant period of time between the time that the defendant first had contact with Chad Olson up until the point of the time of the shooting, sufficient to demonstrate enough time to develop ill will, hatred, spite, or evil intent, coupled with the defendant stating after the shot, words to the effect of throw popcorn in my face. With respect to the aggravated battery, under the transfer and intent doctrine, we have presented sufficient evidence for that case to go to the jury as well, as the defendant did intentionally shoot Chad Olson. Nicole Olson's hand was in front of his chest at the time of the shooting, and she did in fact suffer great bodily harm, permanent disfigurement, or permanent disability, or the defendant did use a deadly weapon, which would be a firearm.
Your Honor, if I can, may just be excused, let me go see if Mr. Funderburg can print up this introduction of final instructions that was left out of the packet that was provided to us by the state.
Okay.
I'll be back in a minute.
All right. I'm gonna deny the motion for judgment of acquittal. I find that the state has provided evidence to overcome the argument of the defense. Thank you. All right, so...
Judge, the only other thing that we probably ought to do is approach.
As the jury receives their instructions, a sidebar here in the courtroom in Dade City, Florida. JB here with you live, folks, on WFLA Now. And we were taking some questions, some comments a little bit earlier on before the jury began receiving instructions. This is the final process before deliberations begin. It is a 6-person jury, and those 6 jurors will determine whether or not Curtis Reeves is guilty of second-degree murder. There's also the chances of lesser includeds that are part of the process. So just because he is found not guilty of second-degree murder doesn't mean he's not going to be found guilty of any additional charges that he also potentially faces, as we take a live look at Curtis Reeves. Now 79 years old. 71 at the time of the shooting. His family there directly behind him, including his wife, over his left shoulder. I want to get to some of the comments, too, that are coming in. Let's go to YouTube really quickly. Deanie Mac on YouTube, #KJB. Why didn't the Olsons move or just put the phone away? We have heard testimony that Chad Olson eventually would go on to put his phone away ahead of the third exchange with Curtis Reeves. But why didn't the Olsons move? They were the ones who were, of course, receiving word that they were, or at least that Chad Olson was receiving word that his cell phone use was bothering Curtis Reeves behind him. And I think that we've seen more, it's interesting. I think we've seen more questions focused on why didn't the Reeves move? But Danny Mac wants to know, why didn't the Olsons move? But yes, to the second point, we have heard testimony that that Chad Olson was putting his phone away around the time that Curtis Reeves was returning from speaking with the manager of the theater. Again, we're live here, awaiting the sidebar to conclude and jury deliberations to begin. Live look at Curtis Reeves. And let me make this clear for our audience here, everybody on WFLA Now across all of our platforms. This is let's go back live. That's recorded video. This is now live. Let me make this very, very clear. When the verdict comes down tonight, if it does in fact come down tonight, I think that there's hope that it will in fact come down tonight. We will be live across all platforms, including the platform that you're watching on right now. We will be live for when the verdict is read aloud here in the courtroom. So while we're still likely some time away from a verdict being read, if a verdict is going to be delivered this Friday, today, February 25th, 2022, just know wherever you are, it might be hours from now, depending on where you are, you can find us on YouTube, you can find us on Facebook, WFLA.com, the WFLA app. We will have live streaming coverage from inside the courtroom as the verdict is read aloud, should it come down here today. Back live, full screen. Curtis Reeves closing his eyes inside the courtroom. It has been a very lengthy 10 days inside the Dade City courtroom. While we're in this extended sidebar, we'll go through some more of the questions with hashtag HJB. Any points of observation. And we were responding earlier to Doreen McDonald in the comment section on Facebook Live with hashtag AJB, and she said, I get what you're saying in responding to me earlier. However, Reeves' accolades mean nothing at this point in time. And number two, he was the original aggressor. He has no one to blame but himself for this unfortunate outcome. And I would just like to point out that this is Doreen's, if Doreen, of course, has been following this trial, this is her observations and how she feels about it. I was bringing up Reeves' accolades because it's what the defense is arguing as part of his character testimony, if you will, that this is somebody who has been a decorated law enforcement officer here in the Tampa Bay area, and that is part of the defense's testimony that they have provided to the jurors. So, again, just highlighting what the prosecution has put forth, what the defense has countered with and put forth on their own, some of the expert testimony that has been brought in speaking to who Reeves is. I think that there's been a lot of folks like Doreen, though, that have been saying that despite his decorated law enforcement career, it doesn't change the semantics of what happened that day in that in that movie theater in Wesley Chapel, Florida. So, again, Doreen, just letting you know, I was explaining in that moment the two sides between both the prosecution and the defense and what they have put forth over these last 10 days for those of you who are maybe just now watching this trial coverage as we get closer to a verdict. Hopefully that makes sense.
Ladies and gentlemen in the audience, in a few minutes we're going to start jury instructions. During the jury instructions, no one will be allowed to enter or leave. So be comfortable or go ahead and go now, because you won't be permitted to come and go during the instructions. Thank you. How's it going?
Good. I'm going to go check with him now.
And every time the courtroom mutes itself, it's 4 sidebar exchanges, just like the one you're seeing on your screen. Point of observation here for those in the audience. On the left side in the audience, and the blonde, you can see, of course, where with the blonde hair, that is Nicole Olson, and members of the Olson family and extended family on the left side of the courtroom. Here on the right, that's Curtis Reeves, of course, 79 years old, and seated directly behind him, over his left shoulder, his wife, other family members here as well. It has been very similar to this. I think that there's even more family members in attendance today, with this now getting to the jury phase of the trial itself.
When we have the lesser one that goes before the aggravated battery, that will make it. I knew that didn't flow right. You went right from the ag bat that hooks with the justifiable use to Nicole's ag bat. It just didn't. I knew there was something missing, so that'll make it much better.
See what the time.
Okay. Connie's on standby to make all the copies, so. Corporal?
Seeing that some of you are noting that there has now been multiple instances where Curtis Reeves has had his eyes closed in the courtroom. This could be for a variety of different reasons. As right there, eyes closed. As we noted earlier, this has been a very lengthy process with a lot of repeated points. So this could just be a moment of inner reflection, could be a moment of just assessing the situation, or it could just be all these days of facts and the mental grind of a criminal trial just bearing weight down on somebody, and somebody just getting a bit tired after 2 weeks of sitting here in court. But yes, a lot of you have noted across YouTube, Facebook, asking about Curtis Reeves and his eyes closed in the Dade City courtroom. Again, I'm going to remind folks, you're live on WFLA now. So the judge has said for days that that once the jury begins the deliberation process, that they are going to attempt to stay beyond normal business hours. So if this goes past 5 o'clock, and believe me, it's going to go past 5 o'clock, the time now, 4:20 Eastern time. This could be a long night, or it could be a lengthy evening. It could extend into the later hours of this Friday, February 25th. But we're going to stay here with you live with coverage, of course, here with you on WFLA.com, the WFLA app, and provide you with the very latest. But when the verdict goes live, we'll be sending out an alert across all of our platforms. A good opportunity to remind folks you can download the WFLA app, as we have Curtis Reeves with his eyes closed here on the right side of your screen. A good opportunity, you can download the WFLA app, and you will get a push alert that you can swipe to open for live coverage when the verdict is read aloud in the courtroom, whenever that might be. It might be today. It might be beyond today. We really don't know. It's a 6-person jury. It depends on the process and whether or not there's jury members or jurors who are in disagreement over the charges themselves. It'll, of course, depend on a lot of different factors that we do not know about at this time, but we will, of course, keep you posted on WFLA.com, the WFLA app, as to when a verdict is going to be reached, if it does, in fact, get reached, in the trial of 79-year-old Curtis Reeves. Here centered on your screen from Dade City, Florida. I just saw a comment to, if you subscribe to alerts on our Facebook page, on YouTube, yes, you will also receive an alert for when we go live, provided that you are, in fact, signed up for those alerts, because I know that a lot of folks who have been diligently following this trial over the last 2 weeks, but at the same time, you got meals to eat, you got responsibilities in your life, can't stare at a blank screen for a long period of time, or even our coverage for a long period of time. If you want to just come back for the verdict, that's a pretty relatively straightforward way to do so, by signing up for push alerts on YouTube, Facebook, or on the WFLA app. In our Facebook Live comment section, Missy Bradburn, hashtag HJB, can you take more questions, please? Thanks. Still want to know why Reeves is allowed to do home confinement when everyone else has to wait in jail for trials, don't they? It's a good question. And, of course, when you have charges filed as serious as second-degree murder, and you have a 43-year-old shot to death in a movie theater, there is going to be a bond hearing, and it's going to be determined what the bond or bail amount is. That hearing did take place, and the judge was able to set bond, and Curtis Reeves made bond. So he has been out on bond. And why is that? Why do some people get bond amounts and some don't? The reason being, well, the judge, of course, has to take into determination several different factors. And those factors can be the severity of charges. Those factors can range from the criminal history of the person who's facing these charges, and of course Curtis Reeves being a veteran of the Tampa Police Department and with an obviously a relatively, I mean, let's just call it what it is, just a perfect record as far as his time with law enforcement in Tampa. I shouldn't say, I'll say it this way, is a sterling record as a member of the law enforcement community here in the Tampa Bay area. That's the way I should be putting it. It is a sterling record across multiple departments, a very decorated career. And so all of these factors come into play when it's determined whether or not someone's going to be released on bail or whether or not they're going to be held in lockup. So hopefully, Missy, that answers your question. Serena Richmond, #JB. If Mr. Reeves goes to prison, how will he feel being a senior citizen? I can't even begin to really answer this question. Mr. Curtis Reeves here, who has been, as we were just talking about, a sterling record with law enforcement and has been on the other side of really countless cases in the Tampa Bay area, being 79 years old, if he were to be convicted, we're talking about prison time where, in essence, he could spend the rest of his life in prison. And for somebody who spent a lot of his career putting people behind bars, it would I can't even begin to describe what that would feel like for somebody. I have never served in law enforcement. I've never worked in law enforcement. I can't even begin. Perhaps our commenters can chime in here, but it would be, I'm sure, for the entire family, including Curtis Reeves, it would be an excruciating result to a career that was spent in enforcing the law, and even going beyond enforcing the law, someone who taught others how to enforce the law here in our section of Florida. So I'll leave it to the other commenters. Feel free to comment along here with us.
The last You guys want to look at this?
I have some questions coming in as well about the jury. It is a 6-person jury with multiple alternates. I believe it's 4 alternates, to my understanding. So that would also explain as to a lot of questions being asked about why there's 6 jurors. And as a reminder, it's very commonplace for there to be alternates in the jury process in the event that a juror is unable to render a verdict in a particular case due to several factors. Let's not forget, too, coming off of the pandemic, having alternates always, it's regularly part of the process when it comes to jury selection. And it is
Possession
a 6
of a firearm and discharge. Excuse me. When there are lessers for manslaughter of second degree is manslaughter. Then the manslaughter instruction. Then aggravation of a felony by carrying a firearm. Then justifiable use of deadly force. BAT 65. Agbat of Chad. Then when there are lessers for the aggravated battery of Nicole, felony battery and battery, then the that needs to go behind. No, that's right. So,
No, there's an aggravated battery for.
right, that goes first. Right.
That goes first.
Okay, so we do have 2 agbats in a row
There's an aggravated battery that
of Chad.
That's right. But
Right.
what you do is, I think when you're reading the justifiable use of deadly force, when you get to that crime where it says any felony battery in 65, then is when you read the elements of it. So when you look at justifiable use of deadly force,
Oh, does it have a spot in there?
when you, like right after you read the crime, to commit the felony offense of battery on a person 65 years of age or older, then I think you say that the court will now instruct you as to the elements of that crime.
Okay, that makes sense.
And then you read the elements for that crime.
And then the same,
Then you go back to the justifiable use of deadly force instruction, and then after you read the aggravated battery, then you say, I'll now read the elements of aggravated battery.
okay, fair enough?
Yes, sir.
You good with that? All right. So, so after the agbat
On
with
Mr.
the,
Reeves,
yeah,
Then there's the,
the agbat of Nicole,
So
and,
after the aggravated, well, yes, I know we're going in order, but after the reading of the aggravated battery, you go back to the
right,
justifiable.
I'll finish that, and then I'll skip those 2 and go straight to the agbat of Nicole, and then after that, there will be lessers of that agbat, which are,
There's the 1020 life instruction after the aggravated battery.
oh, I don't have that in my package, do I?
you did
There it
that.
is, yeah, it was out of order, okay, so, that goes, the 1020 life goes right after the agbat,
Yes,
Correct.
Nicole's agbat, and then when there are lessers,
right.
okay. And then those lessers are instructed,
Felony battery and battery.
yep, then transferred intent, plea of not guilty, weighing the evidence, defendant's statements, rules for deliberation, single defendant, multiple counts, cautionary instruction, verdict, and submitting case to jury.
The single defendant multiple counts goes after you go through the verdict form.
Okay. Okay. So, let's see. Cautionary, yeah, cautionary comes
instruction,
before
verdict.
verdict. Yep, you're right, it
Make the
does. then single, then submitting case to jury. Okay.
Single suspended won't count, and then the submitted case.
Verdict, yep, right. All right. So, anybody have any comments, questions, problems?
I think just for the record, the state will say that the state's reviewed all the jury instructions and we have no objection to them.
Okay,
No objection for the defense.
all right, very good. Then, when we bring them back, I'll begin instructing them. They'll each have a copy, as will all of you. I need 16 copies.
19.
Why? Oh, court reporter, clerk, okay. So I need a total of 19, so that'd be 18 copies, right? We got one? Okay. Well, I'll instruct them. At the end of the instructions, I'll call you all up and ask you if I read them as we agreed, and if there's any objections that aren't of record, you'll step back, then I'll release the alternates, and then they'll go.
When you want to do the computers,
Oh, yeah.
when you talk about the jury, the evidence will go back with you and.
Yeah.
We have.
The deputy clerk will be sure that all of the items in evidence are gathered together along with the verdict form. And I'll tell them then.
And that the exhibits on there are preloaded with
Uh-huh.
what's there, so they don't have to.
Right. Look for them.
Right.
Just take anything out of, it's already on there, right? Okay.
And Judge, what evidence is staying back?
The gun, yeah. All right.
Your Honor, I spoke to the jury, if I may, that the videos from the defense have submitted, the videos that the state has submitted, along with the audio recording, there are other items of evidence that are not on them. So in other words, if they want to look at photographs, for instance, that were entered into evidence, they wouldn't find that on the laptop.
Okay.
They're just the video and just the audio recording of the interview. So they have to know that to find something else, they're going to have the photos and other items back there, with the exception of the firearm that you're going to talk to them about.
Mm-hmm. Only the videos and the audio
The interview
Statement.
of Mr. Reeves.
interview of Mr. Reeves.
And that interview's on both.
Okay.
And Judge, they need to check all that unless they.
Yeah. You guys will check the evidence before it goes back, right? Or look through it?
Yes, Your Honor.
Tammy,
Somewhat
were you able to go
important.
through that list?
Yes.
So that's
Yes and no.
our yes and no?
Uh, Are you giving it to him in a box?
Yes, Judge, it's all in the box.
All
It's
right.
somewhat in order of each thing. You've got the big photos.
Okay, so I'm going to say photos and the other exhibits will be given to you in the box, provided to you. Okay. All right, so while she's making those copies, if anybody needs to use the restroom, which I'm going to go real quick. It'll take just a few minutes and then we'll be ready to go.
I just need to go once. Once they go out,
so I'm like, I'll wait.
That's your disposal.
Okay.
A live look at Curtis Reeves, his representation. There's Curtis Reeves, his wife, making her way for the hallway of the courtroom, and everyone likely getting in a bathroom break if they are to remain inside the courtroom for jury instructions being read aloud. This is their opportunity to just stretch their legs, get a breath of fresh air, use the restroom. And we are soon going to hear from Judge Susan Barthel on the jury instructions that are going to be read aloud in the courtroom, and then deliberations will get underway. Jury instructions, jury deliberations, and then a verdict in the trial that has been 8 years in the making, the trial of 79-year-old Curtis Reeves. I'd like to bring this up from one of our commenters, from one JB to another. Hello to Jack Brown joining us on Facebook Live. He says, #AJB in the state of Florida, any capital cases requires 12 jurors to be present. However, in most felony cases, only 6 jurors are required to try the case. This is accurate. Capital cases, cases involving the death penalty, that's going to involve a 12-person jury plus alternates. In this particular case, is a second-degree murder trial. That is a felony trial. That is going to classify as a 6-person jury plus alternates. I believe it is a 4-member alternate jury that are ready to take the place of a primary juror in the event that that juror cannot render a verdict for a reason such as illness or a variety of other reasons that would come into play as to why a juror wouldn't be able to exercise that duty. But thanks to Jack for clarifying this as well. Just wanted to let folks know that his comment in the Facebook Live comment section was accurate, because a lot of people were asking questions about the jury process. Diane Harris asking, #AJB, how many high-profile murder cases has this judge held? I don't have this information in front of me, but I do know that Judge Susan Barthel was, in I believe it was 2017, I have to check my notes, but 2017 she was the trial judge for when it was determined that Reeves was going to stand trial, because this trial did not fully, it didn't classify as a stand-your-ground case. She was the presiding judge in the court proceeding there. So she has been part of this process, part of Curtis Reeves and the legal proceedings of Curtis Reeves even before this trial began 2 weeks ago. Look for some more. Lisa Clark, will go to some YouTube comments. Lisa Clark, #AJB. I've been in movie theaters with primarily older audiences. Once I was yelled at for putting my phone on silent, and another time for simply eating popcorn. Age and status is no excuse for murder. Well, I think we can all agree on that last part. Age and status, no excuse for murder. And, it's interesting. A lot of folks have been commenting about what was lengthy testimony as to Curtis Reeves and his decorated law enforcement career. That has been a massive part of the case presented by the defense. And a lot of folks in our comment sections have said, basically asked, why are they spending so much time about this? This isn't a case where his law enforcement career is on trial. His actions that day in Pasco County are on trial. And it's because the defense, and I'm giving you an explanation, the defense is trying to establish a case in point to be made here that the jury should examine that Curtis Reeves, over his law enforcement career, including helping to start the SWAT team at Tampa Police, detective work, a lengthy law enforcement career across multiple different departments, and including training others on how to exercise their responsibilities as a Tampa Bay area law enforcement officer. He never once discharged his firearm in the line of duty. So they were trying to make a point that he is a decorated law enforcement officer, one who was decorated enough to be able to train others in the area of law enforcement, and he never discharged his firearm previously over his long and lengthy career as a Tampa Bay law enforcement officer. So that was part of the defense to say, if he had to do it in this case, in the Wesley Chapel movie theater 8 years ago in January 2014, then he did so for the reason of he felt that his life was in danger and that he was acting in self-defense. That's just the argument that has been presented. But I will tell you, I pay attention to your comments. When I hear this testimony, I see the evidence presented, I'm watching your reaction in the comments. I read tens of thousands of comments a week. It's part of what I do here at WFLA Now. And I will tell you that there has been a very vocal group of you in the audience across multiple platforms saying what I said earlier, that his law enforcement career isn't on trial, that his actions that day are on trial. But this is part of the defense that is being presented here. We'll try to take some more questions here in just a moment. Use hashtag KJB if you'd like to ask a question or make a point.
Everyone should be seated.
Yes. Oh, okay.
Detective Smith told me that the batteries, because of their age, I mean, they're very low.
For those of you just joining us seeking an update, the jury is going to have instructions read aloud momentarily. At that point, they will be sequestered. They will retreat for deliberations before a verdict is reached. If a verdict is reached in this case. Again, all 6 jurors in the case have to rule unanimously. Otherwise, we have a hung jury. But we will see what happens, and jury instructions are about to begin.
Excuse me. Oh, yeah. Good. Thank you, Connie. Have a good weekend. Thanks. All right.
We've had a lot of commenters voice their opinion on how the verdict is going to be reached and what that verdict is going to be. I have seen comments on Facebook and YouTube, some saying guilty, some saying not guilty. I want to read this one from Blind Kimberly 13 on YouTube, hashtag
Right
HeyJB.
here.
I wonder how many people are torn as far as guilty or not. I am, but leaning towards not guilty based solely on prosecution's lack of proving Reeves didn't feel that his life was threatened. This is the opinion of one of our commenters saying that they could see it going other way, torn as far as guilty or not, but leaning towards not guilty. I think we've seen a lot of comments come in over the last couple of weeks, but if you've been watching this trial from day one and you've heard the testimony, you've seen the evidence, you are best equipped to be able to
They're not
answer the
answering.
question.
Yours in the courtroom, Your Honor.
Very good. Thank you, Deputy. Thank you, ladies and gentlemen. Deputy Martin's about to hand you all copies of the instructions, and I'll get started. Thank you all for returning. Were you all able to abide by my instructions during that last recess? All right, thank you. All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Statement of charge. Curtis Reeves, the defendant in this case, has been accused of the crimes of murder in the second degree and aggravated battery. Introduction to homicide. Curtis Reeves is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Chad Olson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Excuse me. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Curtis Reeves may be found guilty of murder in the second degree or any lesser included crime. murder in the second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Chad Olson is dead. 2, the death was caused by the criminal act of Curtis Reeves. 3, there was an unlawful killing of Chad Olson by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Possession of a firearm and discharge causing great bodily harm or death. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm or the death of Chad Olson, you should find Curtis Reeves guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find Curtis Reeves guilty of murder in the second degree with discharge of a firearm. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find that Curtis Reeves guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that Curtis Reeves, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Chad Olson is dead. Pardon me? Yeah. And 2, Curtis Reeves intentionally committed an act or acts that caused the death of Chad Olson, or B, the death of Chad Olson, that was A. B, the death of Chad Olson was caused by the culpable negligence of Curtis Reeves. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Aggravation of a felony by carrying a firearm. If you find that Curtis Reeves committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, or used a firearm, you should find him guilty of manslaughter with a firearm. If you find Curtis Reeves committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, or used a firearm, then you should find him guilty only of manslaughter. Justifiable use of deadly force. An issue in this case is whether Curtis Reeves acted in self-defense. It is a defense to the crimes of second-degree murder and manslaughter if the death of Chad Olson resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable if Curtis Reeves reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older upon him. And I'll now instruct you on the elements of battery on persons 65 years of age or older. The crime of battery on a person 65 years of age or older involves the following elements. 1. Chad Olson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. And 2. Curtis Reeves was at the time 65 years of age or older. It is not necessary to establish that Chad Olson knew or had reason to know the age of Curtis Reeves. Unintentional touching or striking includes situations where Chad Olson knows that a touch or strike is substantially certain to result from his act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of an aggravated battery against himself or another. And I'll now instruct you of the elements of aggravated battery. The crime of aggravated battery involves the following elements. The first element is a definition of battery. 1. Chad Olson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. 2. Chad Olson, in committing the battery, A, intentionally or knowingly caused great bodily harm to Curtis Reeves or permanent disability to Curtis Reeves or permanent disfigurement to Curtis Reeves, or B, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Unintentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing Curtis Reeves need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Curtis Reeves must have actually believed that the danger was real. If Curtis Reeves was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Curtis Reeves and Chad Olson. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Curtis Reeves was justified in the use of deadly force, you shall find Curtis Reeves not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Curtis Reeves was not justified in the use of deadly force, you shall find him guilty if all the elements of the charge have been proved. Aggravated battery. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. Curtis Reeves actually and intentionally touched or struck Nicole Olson against her will. 2. Curtis Reeves, in committing the battery, A, intentionally or knowingly caused great bodily harm to Nicole Olson or permanent disability to Nicole Olson or permanent disfigurement to Nicole Olson, or B, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. possession of a firearm and discharge causing great bodily harm or death. If you find that Curtis Reeves committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm or the death of Nicole Olson, you should find Curtis Reeves guilty of aggravated battery with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Curtis Reeves committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find that Curtis Reeves guilty of aggravated battery with discharge of a firearm. If you find that Curtis Reeves committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find Curtis Reeves guilty of aggravated battery with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that Curtis Reeves, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of aggravated battery are 1, felony battery, and 2, battery. Felony battery. To prove the crime of felony battery, the state must prove the following 2 elements beyond a reasonable doubt. 1, Curtis Reeves actually and intentionally touched or struck Nicole Olson against her will, and 2, Curtis Reeves caused Nicole Olson great bodily harm, permanent disability, or permanent disfigurement. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Battery. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. 1, Curtis Reeves intentionally touched or struck Nicole Olson against her will, or 2, Curtis Reeves intentionally caused bodily harm to Nicole Olson. Transferred intent. If a person intends to shoot a person and in the process shoots a different person, the law transfers the intent to shoot the intended person to any person who was actually shot. However, if the death of Chad Olson resulted from the justifiable use of deadly force, then you must find the aggravated battery or felony battery or battery of Nicole Olson was also justified. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you shall find the defendant not guilty. If you have no reasonable doubt, you shall find the defendant guilty. It is up to weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. The jury is not to discuss any questions that a juror or jurors wrote that was not asked by the court and must not hold that against either party. 8. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilt, it should be for the highest offense the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. I have them here. There's 2 of them. They will go back with you with the evidence. It has the caption at the top of the page, in the courts of the 6th Judicial Circuit and in Fort Pasco County, Florida, State of Florida versus Curtis Judson Reeves. It's got the case number, and the first one is the information for count 1, murder in the 2nd degree, and it has verdict. We, the jury, find as follows. Check 1 and only 1 on this form by inserting a single check mark on the line next to the description of the verdict which you have found. And the first line is, the defendant is guilty of murder in the 2nd degree as charged. Under that, it says, if and only if you find the defendant guilty of murder in the 2nd degree, then please further find as follows. Check 1 and only 1. The first one says the defendant did discharge a firearm during the commission of the offense, and as a result of the discharge, death or great bodily harm was inflicted upon Chad Olson. The second one is the defendant did discharge a firearm during the commission of the offense, and the third one is the defendant did actually possess a firearm during the commission of the offense. Then you go to the next page. And it says, number 2, the defendant is guilty of manslaughter, as included. And it says, and then it says, if and only if you find the defendant guilty of manslaughter, then please further find as follows, and check one and only one. Well, there is only one there after that one. The defendant did personally carry, display, use, threaten to use, or attempt to use a firearm. And then the third choice is the defendant is not guilty. So say we all, this 25th day of February 2022, then there's a line for the signature of the foreperson and the printed name of the foreperson. The second verdict form is for the second count, information for count 2, aggravated battery. It's got the same caption and the same thing, verdict, we the jury find as follows. Check one and only one on this form by inserting a single check mark on the line next to the description of the verdict which you have found. The first one has a line, number 1, the defendant is guilty of aggravated battery as charged, and then it's got the questions below that. If and only if you find the defendant guilty of aggravated battery, then please further find as follows, and check one and only one. The first one says the defendant did discharge a firearm during the commission of the offense, and as a result of the discharge, death or great bodily harm was inflicted upon Nicole Olson. The second option is the defendant did discharge a firearm during the commission of the offense, and the third option is the defendant did actually possess a firearm during the commission of the offense. There's also page 2, the next page. That has the number 2 on it. And it says the defendant is guilty of felony battery as included, or number 3, the defendant is guilty of battery as included. And the fourth option is the defendant is not guilty. So say we all, this 25th day of February 2022. And again, signature of the foreperson and printed name of the foreperson. Single defendant, multiple counts or informations. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately in a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. Submitting the case to jury. In just a few moments, you will be taken to the jury room by the bailiff, and the first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or email communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate, And if you wish to see the firearm exhibit, please request that in writing. You will also receive 2 computers for use in viewing the video exhibits and to listen to the interview of Mr. Reeves. One of the computers has the state exhibits and the other has the defense exhibits. Both have the interview of Mr. Reeves on it. Only the videos and the interview of Mr. Reeves are loaded on the computers. Photos and the other exhibits will be provided to you in the box. And when you get the computers, when you get them back there, please plug them in immediately because the battery will die quickly. So go ahead and plug them in as soon as you get back there. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. And there are instructions on the top of each of the computers so you can tell what to do. It's pretty simple by all accounts. I think I could handle it myself. So I'm sure you guys will be able to figure it out. If you can't, simply knock on the door and write your question and hand it to the bailiff. She can't answer any questions except for, is there more toilet paper or something like that, but anything about the case at all, she can't answer any questions. So just write them on a piece of paper as indicated in the instructions. All right, counsel approach.
As we get closer to the jury deliberating in the Curtis Reeves trial, live on WFLA Now. We are now on day 10 of the Curtis Reeves trial. A live look there at Curtis Reeves. This is from the courthouse in Pasco County, Dade City, Florida. A verdict could come later on this evening or tonight, depending on, of course, the jury process and how well in tune and how much in sync the jurors are when they begin and get further into deliberations. The latest on WFLA.com, the WFLA app.
All right, first of all, well, we'll get to that in just a minute. All right, at this time, let's see, I have some alternates to excuse. That would be juror number 7, 8, 9, and 10. It is the duty of the court to release you from further service on this jury. Because of the order in which your names were drawn, you have been seated as alternate jurors. It was necessary that we have you serve in case one of the other jurors was unable to complete his or her service, and fortunately they have all been able to complete the trial. I can't let you go back in the jury room with your former fellow jurors, but you're welcome to remain here in the courtroom if you wish to hear the verdict. If not, you are free to go. And on behalf of all of us, I can't even tell you, I'm going to get choked up, so I'm just going to make it brief, how much we appreciate you guys. This has been a long and tough trial, and we all appreciate your attentive attention and attendance every day. And I know it's been a lot of time out of your lives, and this goes for the rest of you too, but I'll talk to you later. But I just want to thank you very much for your time and attention. So you are now discharged from your service as jurors, which means you can do whatever you want. Just leave your badges with the bailiff, and did you give them? You got them? Okay. All right, so you can, you'll go with Deputy Martin real quick, and you can either stay or go. Just let him know back there. Thanks, you guys.
Leave your stuff. Yeah. You got your badge? Just drop it in that chair. Okay? There you go. I'll leave that one stuff in your chair and do this is for you. That's for you. You're very welcome. Thank you. Here. That's for you. And this is for you. Thank you.
All right, and there's a couple errors that we noted on the instructions, so if you could pass your instructions up and I'll write on them real quick. It's just a couple of words and a number that needed to be put in there. And while we're doing that, you can probably take them back and we'll assemble the evidence and the computers, and you can go back and get comfortable. And Tina will bring all the stuff to you shortly. We'll wait just a minute. Yeah. All right, you guys can go deliberate shortly. Here, I'll give 3 to each table. 3 to each table.
Yes, okay. For them to fix the
Yeah.
table, okay?
3 to each table.
I just need mine fixed too when they get done.
Which one?
Whatever they're fixing.
Oh, yeah. Mine too. I'll show you if you want.
With the verdict form or no?
Verdict forms are right here. It is hot in here. Yeah, give them to those. All right, so on the manslaughter, Yummy, manslaughter. No pages. Right, the number 2 next to the A. Okay. And
Some final modifications to the paperwork, the instructions for the jury as they begin deliberations.
yeah, it is on the verdict.
Live look at Curtis Reeves and those in attendance in the courtroom in Dade City, Florida, in Pasco County, where the shooting occurred 8 years ago. The shooting of 43-year-old Chad Olson, a fatal shooting. Pulling the trigger was 79-year-old Curtis Reeves, former Tampa police veteran, a retiree of the Tampa Police Force.
Was it just the 2 changes?
And after 8 years,
Mr. Rosenwasser? Was there just the 2 changes? Okay, thank you.
his fate now in the hands of the jury.
Okay.
Hey folks, JB here with you live on WFLA Now. Jury has left the courtroom, according to 8 on Your Side's Jeff Patterson, who is there in Dade City covering this and is on day 10 of covering this. You heard there as well the 4 alternates, jurors 7, 8, 9, and 10, being sent home, discharged from their duty as serving as alternate jurors. They were there in the event that one of the 6 primary jurors were unable to carry out their duty as far as rendering a verdict in this case or serving as jurors in this case. Very curious to, of course, curious to know what those jurors would have decided in this case, but their service no longer required, as it now comes down to the 6 members of the jury itself that will determine the fate of 79-year-old Curtis Reeves and whether or not he is guilty of second-degree murder, a felony, or one of the lesser charges included here in the court proceedings. We will find out, and we could find out tonight. It is a 6-person jury, and it depends on how they see the case and whether or not their views on the evidence and testimony presented are aligned. If they aren't, it could be a very lengthy evening, a very lengthy night, and it could carry on beyond this Friday, February 25th, 2022. As we look here live in the courtroom, Judge Susan Barthel, who you've been hearing from, reading the jury instructions. We've been seeing Curtis Reeves. We've been seeing Nicole Olson. We've been seeing Vivian Reeves. That's the wife of Curtis Reeves. Attorneys for both sides. You've been hearing from Prosecutor Scott Rosenwasser. You've been hearing from Rick Escobar. That's the defense attorney. And again, this all occurring over texting in a movie theater in January 2014. Let's go to the comment section. Over the last several minutes, we've put in the chat that you can use hashtag AJB to ask a question or to have your comment featured as we try to, and why do we do that? We do this for a couple of reasons. One, to make sure that your voice is heard. We want to let you know that we're, of course, always spotlighting the comments that come in our comment section. Of course, that they have to be appropriate for air and topical as far as the case that we are covering here, the story that we are covering. But if you use hashtag AJB, yes, you can have your comment featured. We also do that to try to explain a bit more about the stories that we cover and give you a little bit more context as to what is happening. If we can use the social media comment section to inform you and help you understand the stories that we cover, we can absolutely do so, and we are going to do so. So let's get to this comment from Rachel. Hello there to Rachel, hashtag KJB. Do you know if they don't reach a verdict tonight, will they come back on Saturday as some courts allow? Yes, they would come back on Saturday as I understand it. This would extend into the weekend. Now, I can't speak for this jury.
Jury instructions, and it's all, and verdict forms all going back?
Yes.
Okay. Just let me know when you've delivered that to them.
Back here with you live. We were just noting with Rachel's comment, do you know if they're going to come back on Saturday if they cannot reach a verdict tonight? The answer to that, as we understand it, is that Judge Susan Barthel would extend this into Saturday, February 26th, as we look here at Judge Barthel. However, and I was just noting, I can't speak for this jury, but I can speak in relation to past cases. And in past cases, there is always this feeling with jurors that if they can come to an agreement before it interfering with the weekend, they will absolutely do their best to do so. And judges oftentimes, too, are very cognizant of that. Everyone's time is extraordinarily precious. The process is more precious than anything in making sure that the verdict is given the appropriate time that it needs for it to be reached. However, judges will be very cognizant of the fact that the weekend is a time for a lot of folks. Sometimes jurors, not that they would ever plan there to be, traveling out of town during a weekend when they are jurors in a case such as this. However, you will see judges very commonly extend on a Thursday or Friday, extend into the evening and nighttime hours to allow for as much time as possible to get in a verdict and complete deliberations before the weekend arrives. It's just common in not just in Florida but elsewhere as well. But if there, all it takes is one, as we say in covering court, covering trials.
The jury is retired to deliberate. Are there any other matters that require our attention at this time?
None from the state.
No, Your Honor, not from the defense.
All right, then we'll stand in recess and await the call of the jury. All members of the audience will have to wait outside somewhere in the courthouse, wherever you wish to go, but you can't remain in here. Counsel can remain in here if you wish. And, of course, Mr. Reeves and probably his family can wait, but everybody else will have to go outside. All right.
Breaking news on WFLA Now. Here is J.B. Buno.
After 8 years, the fate of 79-year-old Curtis Reeves is now officially in the hands of the jury beginning deliberations in the trial of the shooting death of 43-year-old Chad Olson in a Wesley Chapel movie theater more than 8 years ago. Hey there, everybody. JB here with you live on WFLA Now. If you're just joining us, the jury has begun deliberations, a process that we're not entirely sure how long that is going to be. We don't know if that is going to be half an hour and a half, 4 hours, 6 hours, 2 days. We don't know. It depends, of course, on how the jury sees the evidence and the testimony that has been presented over 10 days of this trial. And we'll try our very best to outline a general synopsis of what has been formed as the prosecution's case and the defense's case against. And we'll try our very best here with some of the questions that are coming in our Facebook Live and YouTube Live comment section. We'll also pay attention to Twitter as well. You can use hashtag HeyJB if you have a question. What we can do while the jury deliberates and while we have this break in the action, we can do our very best to spend some time with you, tackle some of the questions that you might have, and talk about the case a little bit more in depth. We can't go in depth to every solid, single quote or piece of evidence that was presented. We can, of course, go over what we know about the trial, and we'll do our very best to do so. So if you would like to be part of the conversation, you can do so with hashtag HeyJB on Facebook, Twitter, or on YouTube. Albert, this is a great question. I believe it's public. Albert Jeffries, hashtag HeyJB, do you know if the courtroom is open to the public? Because I understand it is a public courtroom. I don't know if there's a process for filing in this particular courtroom in Pasco County, and that's the Dade City is the county seat in Pasco County, Florida, where the crime is said to have taken place, and Wesley Chapel also in Pasco County. So I'm not sure if you can just walk in there tonight if you were curious, but I want to bring up Kathy's comment, hashtag HeyJB. If I was one of the alternate jurors, I would definitely stick around to hear the verdict. I'm with you, Kathy. I think that if I was an alternate juror, and just speaking for myself here for just a second, I would want to know. I had committed 10 days of my life hearing all the facts presented from both sides in this case, hearing the cases for guilty, hearing the cases for not guilty. And I would be extraordinarily curious to know what the result is going to be. And I would imagine I wouldn't surprise me if all of them, if a majority of the 4 alternate jurors were sticking around. Or they can find us on YouTube and Facebook and be in the comfort of their own homes when a verdict is reached, if it is in fact reached. Remember, if a hung jury is the result of the deliberations, then we have a mistrial. Potentially we have a mistrial. So it's very important to note that we are hopeful for a verdict tonight, whether it be guilty or not guilty. We're hopeful for a verdict in due time, but we do not know how long that process is going to be. Andrea, #AJB, a 6-person jury seems small. Is that standard? We'll go to some video from the last couple of days. It is for the charge. So as we were noting earlier, and I'll bring Jack's comment back up, 12 jurors for a capital trial, involving the death penalty, but felony cases in Florida are typically standard 6 jurors. Now, you have to have alternates. You can't compromise the integrity of the trial by not having alternates. Alternates are part of the process. So you just heard Judge Susan Barthel discharge those alternates, despite having all that knowledge in their brains, all that receiving all of that information over the last 10 days. They will not be charged with rendering a verdict in this case and being part of the verdict process. So, let's see. Look for some more on Facebook Live and YouTube Live. This is funny. This is the most I get this of all the questions that we get more than any. It's this one. It's Deanna Lynn, #HJB, why did it take 8 years for this case to get to court? And really, I'm just going to go over the short version of this answer. It was hung up it played ping pong in court for a long time as they were trying to determine whether or not it should be classified as a stand your ground case. Ultimately, it was not considered to be and ruled to be a stand your ground case. And then pandemic also played a factor with this case and so many other cases here in the state of Florida. Will I am in the comment section, #KJB, if he's found guilty, what is the max sentence length? And audio on. So I'm just going to do it right here. Yep.
No one's going to be at the podium match. You don't get to do that anymore, right? We might just have it just in case, maybe. Okay.
There's 3 in there. Okay. But you got, so you just, yes, them. I know there's 3 in there. Okay, so this right here.
It appears we're just picking up some side chatter in the courtroom, and this can be for a variety of reasons, mic checks, a lot of different reasons as to why we're picking up some stray audio. To answer the question, if Curtis Reeves is found guilty of second-degree murder, he will, in all likelihood, spend the rest of his life behind bars. It carries a maximum sentence of life in prison. And sentencing, of course, would come at a later date. But I believe, and I remember from my notes, I believe it is a minimum of 25 years on that charge. So he's 79 years old. And in all likelihood, he would spend the rest of his life in prison if he is convicted on that charge. Now, there's lesser charges that could come into play if he is found not guilty of second-degree murder. And then, of course, we would go over the potential sentencing that could come with those associated charges. But as of right now, all eyes are on that second-degree murder charge, the felony charge in Pasco County Court. You know, this is a question that I'm going to leave this up to our, you know, when we cover cases of murder or manslaughter, remorse is a theme that gets tossed around quite a bit in our Facebook Live comment section. And whether or not there is the appearance of remorse. WFLA Now is about your opinions. It's about what you think in response to the stories that we cover. So I'm going to just bring up Sandra's comment, and I'm going to kind of spotlight this for a second, because this is important to people. When I talk to people about court cases and trial coverage, they're looking for humanity, those moments where somebody shows that they are a human being. And they're looking for moments that they can try to read into the mind of a person connected to a case involving somebody's death, whether it be murder or manslaughter. So Sandra Ann says, #KJB, has Reeves ever shown any remorse for killing a child's father? And I think that we'll just say that that this is up to, we pose it to you, and feel free to comment. You can use #KJB. You've been, especially for those who have been really watching this over the last 2 weeks, and maybe who have been following this in a court of law, you know, as it was tried as it was making its way through the court system as a potential stand your ground case. This has been going on for 8 years. Do you remember moments, whether it's in the last 2 weeks or in the last 8 years, where you felt that Curtis Reeves was showing remorse? This is up to you. You let me know, and we'll spotlight some of the comments that are coming in. And reading through some more comments. I can't bring them on screen unless we use #KJB. To Sherry Davis saying, where am I? I'm in Tampa. Tampa, a little bit. Tampa, of course, the largest municipality on the Gulf Coast side of Florida. We are, I would say we're about an hour away from where the courtroom is. We're about an hour drive north without traffic to Dade City and Pasco County. Maybe a little bit, maybe slightly more. Trying to remember the last time I did that drive from Tampa to Dade City, but yeah, about an hour or so away. Hillsborough County is where Tampa's located. Pasco County is directly north, and that's where this trial is taking place. We'll bring up Rachel's comment. Again, it's got to have the hashtag, any hashtag on your screen, but considering I'm solo here, it's #KJB. Otherwise, if we were with Masa Saidi, it would be #HeyMasa, or if we were with Walt Pito, we would spotlight #HeyWalt. It's just me. So Rachel says, #KJB, most don't show remorse. They believe they're innocent. But I'm not talking about this case, I'm talking generalities. You can still show remorse for a terrible act that has occurred and still believe you're innocent. You can believe that you're innocent of the crime that you are charged with, but still express remorse for the fact that it happened. So I want to point that out as well. And it's really up to you at home whether or not you believe Curtis Reeves had expressed remorse. All right, let's go to Rebecca's comment. Hi, Rebecca. #KJB, been following the whole time on Court TV. I have not seen remorse. He is, in my opinion, guilty of second degree after watching it all. Okay, so Rebecca says that she's been watching for the last 2 weeks, and that is her opinion. Says no remorse and is guilty of second degree murder, a felony charge here in the state of Florida. Let's go over to YouTube. Let's see. Kitty Martin, hashtag AJB. Am I right in thinking the defendant's lawyer will always instruct them to remain emotionless? I think they do. And Kitty sends love from England. Love to England right back. I want to make it over to the UK one day. Kitty, so fascinating conversation. And I think that later on tonight we're going to be on with some legal experts to perhaps break this down. Maybe I could pose it then, but I'll say this. Defense attorneys and the prosecution, but really defense attorneys are well aware when a court proceeding is being fed out live to the public at large. And there's absolutely a conversation that takes place about the appearances of those who are in the courtroom because it's being fed out live. And I can't speak for what Rick Escobar, the defense attorney, what those conversations were like, but I can almost guarantee you that it was made very, very clear to his team, including, of course, the client that he is representing in Curtis Reeves, that this is being played out live for the world to watch. And there's going to be times where even when, with it being a court TV situation, that even when evidence is being presented, they're going to have cutaways, and they're going to show Curtis Reeves, and they're going to show Nicole Olson. There's going to be different camera shots shown on the live feed coming out of the courtroom. That's absolutely discussed. But what tactics and what advice is given, I can't speak to. But your question was, could he have been instructed to appear emotionless? It's absolutely possible. It's absolutely possible. Comments are starting to come in pretty fast all of a sudden, so I'm going to try to read through as many as I can. Blind Kimberly 13 says, hashtag AJB, I feel he's morally guilty, but I don't think he's going to be proven guilty. Saying, I don't think they proved his guilt beyond a reasonable doubt. Oh, that's very interesting. Mandy Lashbrook. Hi, Mandy, on YouTube. Hashtag AJB, I've been following this trial, and I've seen no remorse from this man. Neil Reed, again, kind of stick with YouTube for a moment. We'll bounce back to Facebook. YouTube. Fran Meller, hashtag AJB. He was a cop all his life. Now he's in court for murder. What a paradox that is. Yeah, we talked about that a little bit earlier. Just the juxtaposition, the contrast in a life dedicated to law enforcement and protecting people, and then shooting a person, killing them, and if convicted, it's just it's a massive 180 on a career that was spent protecting people and putting bad guys in jail and in prison. Now to finding yourself potentially behind bars yourself, it's a massive turn of events for a man who had an incredible reputation and a pretty sparkling record as far as his law enforcement career in Tampa Bay. Field Blazes, hashtag AJB, you're still on live to the world. Thanks for talking through it without being biased. Just waiting for the actual verdict. Yeah, that's what we do. We just try to present you with information and try to talk to you guys and discuss the stories that we cover. And as far as the verdict, the verdict is going to come at some point. Don't know. There's no telling when. But let's go back to kind of a little bit of a strategy here. It's 6 o'clock Eastern time. You might be thinking, hey, some dinner sounds pretty good, or maybe you're eating dinner right now watching. But maybe you want to just hang out with your family, or you want to go out to a restaurant, so on and so forth. Whatever it may be, you might have other things to do tonight. It's your Friday night. If you would like to get alerted to the verdict, you can absolutely do so. Just sign up for alerts on YouTube, on Facebook, live. Look for there's a button, usually it's like a bell button, and they change it all the time, but it's usually a bell icon where you can sign up for push alerts on the social media platform of your choice, or the most surefire way is downloading the WFLA app on your phone. You can turn on push alerts, and then the alert will come in. Believe me, the alert will come in, and I think it's even faster than Facebook or YouTube. It's less of a step. So it's the fastest way to find out that a verdict has been reached is by downloading the WFLA app. I believe that the beginning to end time from when we send the alert that the verdict is in to where you get it in your phone is 1.5 seconds. It's extraordinarily fast with how technology has developed in recent years. So, and then you'll swipe to open it on your phone or on your tablet, and you get taken right to here, to WFLA Now, where we'll have the verdict for you and verdict coverage. Eric McDowell says, hey, JB. Hi, Eric. Hope you're well. A lot of great folks on YouTube. Let me see this. Some of the comments I'm having difficulty reading for one reason or another, because sometimes there's typos in them. Sandy Rodriguez says, hashtag HeyJB. I watched this trial and the 2017 hearing. Difficult case. Both men were alpha males, wanting the last word. Why didn't one man just move? Maybe because you honed in on it right there. I'm just gonna kind of take your context there, Sandy, and just and flip it right back around. Why didn't they just move? Well, in the way that you described it, because they were alpha males. And if, again, within that paraphrased version of how you've described it, alpha males, the whole definition of being an alpha male is to rise above others. And when you can't rise above others as an alpha male, well, then you have confrontations. Because when you have that dynamic, you have two people that are just trying to escalate above the other, and before you know it, you have the eruption of a very serious situation potentially. So I think you kind of answered your own question within your own question. Oh, wow. JBWK, hashtag HeyJB. Watching from England, I find the use of a gun in self-defense is so different across the United States. Watched the whole trial and moments of flashbacks to the Rittenhouse trial. So how so different? I understand that it's easy to look at the Rittenhouse trial and see it as another case of an argument for self-defense. And I understand the line of thinking there, but they are completely different cases with completely different dynamics and different variables at play. And just think of what was going on around Kyle Rittenhouse at the time of when he fired his weapon. The streets of Kenosha were chaotic that night. This is a movie theater where people bring their kids and to go to the movies and eat popcorn and candy and enjoy being transported to a different story, a story outside your own world for a moment, for a couple of hours. And so I'm not even going to go down the road of comparing. They're just so incredibly different. I understand that there's some that it's a case involving self-defense, but they're apples and oranges to me. They're extremely different. Also, too, I indirectly covered the Rittenhouse trial. Indirectly. What does that mean in TV terms? So, indirectly covered it, meaning that I covered it from afar. I'm a TV reporter in Florida. I'm a broadcast journalist in Florida, and I mostly cover Florida stories. Now, the Rittenhouse trial I covered, but I didn't cover as extensively as this one. I can't speak to the specific details within the Rittenhouse trial that I could in the Curtis Reeves trial, because that's the assignments that we're given as journalists. We all get assignments, and my assignments are hyper-focused on the Tampa Bay area and beyond that, the state of Florida. But I know from doing enough with the Rittenhouse trial from afar that the cases are completely different. Let's go back to Facebook. Jack, I think I understand what you're trying to say. I think. Hashtag AJB, he may have had remorse, but after being convinced it was justified, he may have lost any sign of it. You know, there was a moment in court yesterday when he took the stand where he said, I've second guessed it, and I've second guessed every move that day. And I don't think that you can just put away the remorse side of it for just a second. I don't think that you can be somebody who has devoted a majority of your adult life to serving others, protecting others, and serving in law enforcement, shoot and kill somebody else. Really, in your community, you shot and killed somebody else. A 43-year-old man in your own community with his own family, his own life, and I don't think it's possible to not second guess every single solitary thing about that day. You ever been in a car accident and you get in a car accident and you think, man, if I had skipped making coffee that morning, or if my dog didn't take so long to do my dog's business outside my house, I would have got in the car sooner that day, and the accident never would have happened because I would have been in a different place at a different time. The trajectory of the day would have changed dramatically. Can you imagine, in this case, all the different things that could have occurred? Think about it this way. Curtis Reeves and Vivian Reeves are there waiting for their son, who was meeting them at the movie theater. If their son had gotten there 10 minutes sooner, would this ever have happened? Would the son have been able to help defuse the situation? Would it have escalated had there been just another person there to help defuse the situation? Now, you could argue that Vivian and Nicole weren't helpful, or weren't helpful, but their presence there didn't defuse the situation. Why would the son arriving make any difference? But when you think about what Curtis Reeves said yesterday, regardless of remorse, just hearing him in his own words say that he has second-guessed every part of that encounter with Chad Olson 8 years ago over the course of the last 8 years, it speaks volumes as to what goes on in your brain in the aftermath of something life-changing. And this was a drastically life-changing moment for both of these families. Just a few more minutes here, folks, before we are going to take a lengthy break. And then after we take that lengthy break, the next time you'll see me will be for one of two reasons. We have a verdict, or the jury is going home for the night. That's the next time you'll see me. I might pop on Instagram as well, too, on my WFLAJB Instagram account, because we can't go live on Instagram, and there's an audience there, too, that have questions. Looking at some more here. So this is the biggest. I'm gonna really spend some time here on Deanna's question, because it's the biggest question in this case. The biggest question, number one question overall, has to do with the cell phone, and was Curtis Reeves hit with anything? Deanna Lynn, hashtag AJB. Did the defense ever get to prove that Curtis was hit with something or by someone? This is a question that is being posed in the minds of jurors, maybe right in this moment. They could be talking about this right now. And it's really up to you at home and the display of evidence that has been presented. But let's just kind of talk about it for a second. The defense is arguing, and Curtis Reeves has said, that he was hit, and that led to the reaction of him pulling out his firearm because he felt he was in fear for his life. Now, he feels that he was hit with a cell phone. What do we have to go by? Okay, we have two things to go by, really. We have the witness testimony. None of the witnesses have ever said that they saw a cell phone fly. None of them did. Because if you're hit with a cell phone and it's been presented that Curtis Reeves might have been hit in the face with a cell phone, and there was no distinguishable, obvious marking on his face to show that he was hit with something. And cell phones, cell phones can get relatively heavy. You hit somebody in the head with this, especially a bigger phone, it's going to hurt. And they put the phone in court, or they showed it in court. It looked like a pretty standard sized iPhone, but yeah, a phone getting thrown in your face or you getting hit with a phone, yeah, that could leave a mark and that could hurt. And but it really comes down to whether or not that phone did in fact strike Curtis Reeves. Now, the video, none of the witnesses have, that's the first thing. None of the witnesses have said they saw a phone hit Curtis Reeves. The second thing, very, very, very important, is the video evidence. Now, the video shows a flash of light. The defense is arguing that that's a cell phone flying or going in the direction of Curtis Reeves. That very minuscule, I think they said 6 pixels, a very minuscule reflection of light. And that light that you see flash in the video surveillance is a cell phone. The defense is pointing to that. The prosecution is saying that's the reflection of Reeves' sneaker, his shoe. And they brought out the shoe in court and they showed the reflective material on it. And they were pointing to video evidence showing that the reflection appears to, in their view, the reflection appears to move when his leg moves. And they are pointing to that reflection being actually not a phone flying or a phone going from Olson's direction to Reeves' direction, but they are arguing that that is a reflection of the shoe itself. It's an enormous part of the case, because if that is classified as an attack, then was Curtis Reeves acting as self-defense? If he was attacked with a cell phone, is he acting in self-defense, and is there more of an argument that he was acting in self-defense and pulling out the gun in the spirit of keeping he and his family safe? Enormous case. Oh, okay, so I've got some news here from Justin Schecker, one of our reporters. This is interesting. He's there. So Jeff Patterson has been covering, just a little behind the scenes of how it works in news. Jeff Patterson's been covering this trial from day one, and he's been there all day today, but he has to get relieved at some point. I don't know what time our newsroom here is going to send Jeff home. Jeff Patterson, one of our veteran reporters here at WFLA. Justin Schecker, one of our Nightside reporters, is relieving Jeff and is there right now. Now, Justin just texted me saying that he is at the Reeves trial and that he spoke to the court PIO. And the court PIO told him that there are no plans as of now to come back tomorrow, Saturday. Interesting. But that could change. And the court PIO might not be privy to the plans of where this goes from here. But just an interesting little tidbit from our own Justin Schecker. Give him a follow, folks. Folks, we're going to get going because we are going to kind of just take a step back for a moment assess where we're at as the jury deliberates, and we're going to be back when we have a verdict or if the jury is sent home for the night. So let me explain how this is going to work going forward. Facebook. Hey, Facebook. Who's joining us on Facebook? I see Sue, Susan, Erica, Linda, Brenda, Patricia joining us on Facebook. Facebook stream is going to end. And the Facebook stream is going to end because social media platforms work differently. Live streams are distributed to audiences differently. So the stream is going to end on Facebook. But for those who use Facebook as their primary source for news, you really want to go over to the WFLA Facebook page. You can also go over to the WFLA JB Facebook page. You can turn on push alerts or push notifications for every time we go live. That'll be really helpful to you because we're about to end the live stream on Facebook. YouTube is different. So YouTube, we're going to stay with you live and be back with you. The player will stay live. And we'll actually resume our coverage within this player once we have a verdict or the jury being sent home for the night. Hopefully that makes sense. Same for WFLA.com. If you're watching on WFLA.com or the WFLA app, don't go anywhere. The player will stay active and live, and you can stay here within this player, and we'll resume our coverage when we have news to bring you on either a verdict or the jury just not being prepared to reach a verdict tonight. I'm hopeful that we have a verdict at some point tonight in these upcoming hours. I'll be sticking around. Might jump on Instagram here in a little bit to talk to some folks on Instagram, on my WFLA JB Instagram account. But if you want to read the latest in the meantime, and we encourage you to do so, and get a lot of video coverage of the trial itself, it's all on WFLA.com, the WFLA app. We have a whole lot more on the Curtis Reeves trial. And again, you can download the WFLA app, sign up for push alerts on your device, and you'll get a notification sent to your phone or tablet the moment that a verdict is reached, provided that we have a verdict to go live with. So if you want the latest, it's on WFLA.com, the WFLA app, Facebook and YouTube. I've kind of laid out the plans for that. All eyes are on Pasco County, Florida, as we await a verdict in the Curtis Reeves movie theater shooting trial. We'll be back here with you on WFLA Now when we have an update.
Live on WFLA Now, this is Hey JB. Here's JB Buno.
Popping into YouTube Live. Hello there, YouTube. JB here with you live on WFLA Now. I want to pass along some details. Again, there is some optimism for a verdict tonight. Verdict in the Curtis Reeves trial. We cannot say whether or not definitively there is going to be a trial, or excuse me, a verdict at some point tonight. But figured I would check in and say hello to everybody who's still hanging out with us on YouTube, awaiting just some news of any kind on the Curtis Reeves trial. Everybody at the courthouse just awaiting the jury and their deliberation process and whether or not that is going to come to a conclusion at some point this evening into really the night. It's now 7:23 Eastern time here in the state of Florida. So just saying hello to some of the folks on YouTube Live. Somebody saying that I look bored. I'm not bored. I'm waiting, as we all are here on YouTube and on Facebook and on WFLA.com, the WFLA app. Our streaming coverage continues once we do have a verdict in this case. Now, as a reminder, you're always welcome to chat here amongst your fellow commenters on YouTube Live. You can, of course, we always ask, keep it civil, be nice to one another, as we always encourage our commenters to do. But if you'd like to, of course, pay attention to some other things, you can always sign up for push alerts, live notification push alerts on YouTube, on Facebook, or you can download the WFLA app. You do so on your mobile device or on your tablet. You can sign up for push notifications, and you'll be among the first to know when the Curtis Reeves verdict comes down in Pasco County, Florida. As a reminder, we're hopeful for a verdict tonight. However, a verdict isn't guaranteed at all. It takes, of course, the 6 jurors seeing eye to eye on the charges that have been presented in this case. And if it's not, then we have a hung jury and potentially a mistrial on our hands. Again, the jury now has been deliberating for some time, and we are remaining. I'm a glass half full kind of guy. I think everybody after 8 years wants there to be resolution in this trial and hopeful that a verdict comes down tonight. But also at the same time, you do not want the process to be rushed. So we are all on standby here at WFLA News Channel 8, all of us in our newsroom, ready to continue our streaming coverage the moment that we have a verdict in this case. But just wanted to give you a brief update while we're here live on YouTube. And saying hello to Wanda, Charlene, Some Guy. That's his name. His name on YouTube is Some Guy. Simplified? Is that what that says? Raymond, Brock, Barker, Boomer Wow, Kassan, Ford, Cheryl Moore, Laura Lee. All of us joining us on YouTube. Hello. I am here with you in the comment section. We're all waiting for a verdict to be rendered in this trial. And of course, we'll stay here with you live on YouTube, and we relaunch our Facebook live stream the moment that we have a verdict, and our trial coverage continues from Dade City, Florida. We'll get back now to the break in coverage that we are currently in, and we're back with the latest on WFLA Now as soon as we have something to report or pass along to you. As a reminder, and I'm just going to pass this along one more time, read the latest. If you haven't been up to date on this case, do yourself a favor. The more equipped with knowledge that you are on the case and the facts and the evidence and the testimony that has been presented, the more value that your opinion has when it comes to the verdict actually being rendered. So you can go over to WFLA.com, the WFLA app, and you can click on the link in the description on this video. It'll take you over to the WFLA website and app where you can read the latest on the Curtis Reeves trial. Back with updates as they become available here live on WFLA Now. Oh, let me pass along one more thing. We'll go back to that music in a moment, the music that just plays on loop endlessly. One more thing, really important. I know that a lot of us, a lot of the commenters on YouTube have we're following along with the Gabby Petito story with the subsequent manhunt for Brian Laundrie. We have a brand new story on WFLA.com. In fact, I'll put a link to it in the comment section for you on YouTube. Let's copy and paste this in here for you guys. A brand new story from 8 on Your Side senior investigator Walt Buteau about he did an interview with FBI expert and retired FBI agent Jennifer Coffendorfer, who revealed something that was bothering her, a bothersome final detail in the medical examiner's report that was released on Brian Laundrie's death. If you want to read more about that, there's the link, throwing it in the comment section for those of you looking to read some content while we wait for a verdict here in the Curtis Reeves trial. So if you've been following the Gabby Petito story, of course, what happened between Gabby Petito and Brian Laundrie, and you would like the latest from us on WFLA.com, just click on the link in the description on this video. All right, sending you back over to the break-in coverage. We're back once we have something to report here live on WFLA Now.
Live on WFLA Now, this is Hey JB. Here's JB Buno.
Checking in with the YouTube live audience. JB here with you live on WFLA Now. Hope everybody's having a good Friday evening, Friday night. Maybe it's Saturday where you're watching from. I'm not sure. What is the time in London? I know we have a lot of folks joining us from the UK. So London time, let's see. Yeah, it's 1 in the morning there, Saturday, February 26th. So they are a day ahead of us over there in the UK. Hope you're having a good Saturday morning, Friday night, Friday evening, wherever you're joining us from. Hope you're having a good one. JB here with you live on WFLA Now. We are on verdict watch for the Curtis Reeves verdict in the movie theater shooting trial, the movie theater shooting that dates back 8 years. 8 years to January of 2014. We're on verdict watch, but we're also kind of at this stage and where we are, we're also kind of, sounds bizarre, but we're also on dinner watch. And I mean dinner watch for the jurors. The jurors have been deliberating now for more than 2 hours. It's been about 2 hours and 15 or so minutes roughly in that window of time. And at some point, the jurors are going to have to just take a little bit of a break just to eat. Now, there's been myths in the past about court proceedings and deliberations when food comes into play, and that sometimes the myth is that can spur conversation along, or at least give everybody just an ample break to at least concentrate on their thoughts. And when they resume from dinner or lunch or whatever the meal may be, that sometimes you're a little bit closer to a verdict then than you were prior to the meal actually getting underway. Haven't heard about that meal taking place, but at some point the jurors are going to have to eat and take that dinner break. We've been staying in touch with our reporters at the courthouse. Right, this is still live. It appears stagnant on the right side of your screen, but even when we go to this look, I want to let you know that phone down there in the bottom left-hand portion of your screen, that's a live feed. So you're seeing live feed, and the audio is up as well. So if there's any audio that comes through the court feed, you're hearing the audio, you're seeing the video. That is a live feed. But as far as the meal itself, we haven't heard any details, but that will likely happen at some point in the next hour or so. Eventually, they're going to have to take a break to eat, and then, of course, how long that takes is then a question. People want to know, okay, how long is the meal going to take? How long will the dinner break be? We'll keep you posted if we hear anything. In the meantime, just want to let you know, we're still here. We're not leaving you until we either have a verdict or we have the jury being sent home for the night. Now, we have been told, and we are hearing more and more from the courtroom, that this is not expected to go into Saturday. We had originally reported that Saturday was on the table. Now we're hearing that Saturday might not be on the table as far as deliberations continuing. It really comes down to Judge Susan Barthel in the end. She'll determine what the best course of action is if a verdict cannot be reached tonight. And if this is extended, then it becomes, okay, when will the jurors resume deliberations? But we're still pretty relatively early in this. Let's make that very clear for our audience. Maybe some who are court experts and court veterans, maybe some of you who have worked in the court system before, those folks know we are really early. In a 9-inning game, we're in the first or second inning here, maybe the third inning, depending on the type of trial that you're talking about. But we're really early in this. And we are hopeful still for a verdict at some point tonight, but no one knows other than those 6 people in that room deliberating right now in the Curtis Reeves trial. So we're going to stay here with you live. We're going to keep the YouTube live player up so that when you see this look and you see that live feed in the bottom left on that phone in the bottom left-hand portion of your screen, you know what is live coming from the courtroom. And we'll stay with you live on YouTube, and then our streaming coverage will continue the moment that we have word that things are picking up pace as far as the action in the courthouse itself. So I just want to say hello to some of the folks on YouTube Live. Old Aerotech, Laura Lee, Johnny Desk, Mark Nelson, Convoy. It's separated there. That's a pretty unique name. Gina, Johnny Osprey, Elliot Garcia, Lisa Whitehouse, Crosby, Steven as well. Steven, what was Steven's last name there? Steven Kinsland. Hello to everybody joining us, and we're not going anywhere. I'm staying here. We're staying here. We're ready at the drop of a hat to resume our streaming coverage the moment that we hear that there's activity at the courthouse in Dade City in Pasco County, Florida. So I know you've heard the music over and over again, but we're going to go back to the music here as the streaming coverage will resume once we have a verdict in the Curtis Reeves trial, or once we have word of actions with the jury, whether that be with a meal or whether that be with them being sent home for the night. Staying here with you live across our social media platforms, live on WFLA.com, the WFLA app.
Live on WFLA Now, this is Hey JB. Here's JB Buno.
We have hit the 3-hour mark in the Curtis Reeves trial jury deliberations here. The time now 8:42 Eastern. JB Buno here with you live on WFLA Now. Hope everybody is having a pleasant either Friday night or, depending on if you're joining us from the UK or elsewhere in Western Europe. If you're over that way, it's Saturday. Happy Saturday to you. And as we talk about Europe, just passing along our thoughts and prayers for those affected by what is going on with Ukraine and the Russian invasion of Ukraine. We have a international audience here, people that join us from around the world. We've had people join us on streams previously from Australia, from New Zealand, from different countries in Asia, from South Africa, from South America. We do reach an international audience here, and have to pass along just my thoughts and prayers for everybody affected by what's going on right now as Russia continues their invasion pursuit of Ukraine. We're here with you live on WFLA Now, awaiting the verdict in the Curtis Reeves trial. Now, we are at the 3-hour mark. We have not heard whether or not there's been any break for the deliberations, whether or not they have paused to take a meal or just, throughout the trial, you would see the judge, Susan Barthel, call for breaks, periodic breaks. We haven't heard if there's been any breaks. We have no idea what the process is like for that 6-member jury that is now separated from the rest of the folks that have gathered at the courtroom as they tried to determine whether or not Curtis Reeves is guilty of second-degree murder, or perhaps one of the lesser charges that falls underneath second-degree murder. So to everybody joining us, I just want to give you a little bit of an update that I've been in contact with our team at the courthouse. Nothing. It's extraordinarily quiet right now, and they haven't been given any updates. And what kind of updates would you get? Well, sometimes there are the court employees that will pass along something to the effect of, hey, they're taking a 5-minute break, or hey, they're pausing for dinner. Some of those, and oftentimes too, sometimes you'll see the judge come back into the courtroom to just kind of request an update. Oftentimes too, sometimes what you'll see is a request for clarification on particular evidence or testimony that can sometimes get read aloud in the courtroom. So sometimes there's different things that will occur over a deliberation process, but passing this along to you, there's been nothing, nada, zero, zilch since we've began 3 hours ago. So yeah, Justin Checker, I see some of you guys talking about Justin. He is at the courtroom, and he's providing us with updates. To everybody joining us, hope you've had an opportunity to get some dinner. I did. I got some dinner while we were in this most recent break, and Chinese. Chinese was the meal, you guys. And as we wait for a verdict, I've got not one, but 2 fortune cookies. One of them I'm going to read for me, and the other I will read for you, wherever you're watching from. So, okay. Let's see this. Fortune cookie number 1 is, I'll read it aloud. This one's for me now. This is my fortune. Adversity willingly undergone is the greatest virtue. Adversity. Maybe this comes after my first comments on this stream regarding what's going on in Ukraine. Adversity willingly undergone is the greatest virtue. But you know what? That can't really apply to Ukraine because it's not willingly. They're being invaded. So I take that back. I don't know how this applies to me. Let's read your fortune. Let's see what the fortune is for our YouTube audience. We're only live on WFLA.com, WFLA app, where there's no comments there. The only place that we're live where comments are on YouTube. Let's read the fortune for our YouTube live audience. Let's see. Okay. A person of words and not of deeds is like a garden full of weeds. How's that for a fortune about social media commentary? A person of words and not of deeds is like a garden full of weeds. It's a combination fortune cookie and poem. Thought I'd share that with you as we wait. We are waiting here for the Curtis Reeves verdict and an opportunity to just talk with everybody out there. Hope that you guys have had a meal tonight. Hope that you, wherever you're watching from, hope that you're doing well this Friday night or Saturday morning. We're hopefully closer to a verdict now than, and hopefully, and I say hopefully closer to a verdict now because, as a reminder, a verdict is not a certainty. The verdict has to be unanimous among all 6 jurors. So if there is a hung jury, it's potentially declared a mistrial, and then what happens after that? It's potentially a merry-go-round. Potentially you go around all over again. So there's a lot of of course, a lot of focus tonight on what's going on in Pasco County, in the courtroom itself. And if I hear anything, even just some chatter in the hallway from the Pasco County courtroom from our great reporting team that's there covering the story, I'll pass it along to you. You can also follow Justin Checker on Twitter. He's actually there. He's waiting as well for more information. And hope everybody sticks around because I remain optimistic that we get a verdict. I don't have any insider information. I'm just a glass half full type of person. And I'm hopeful that we do have a verdict at some point tonight. This has been 8 years, you guys. 8 years of waiting about whether or not Curtis Reeves was justified in his actions that day in pulling out his handgun and shooting Chad Olson to death. Was that a justifiable act of self-defense? Or was it the act of murder or manslaughter? The verdict will paint a picture as to what is going to happen to Curtis Reeves going forward, and we remain hopeful that we get a verdict tonight. In the meantime, I have some fortune cookies to eat. In the meantime, you can read the latest on, WFLA.com, the WFLA app. You've been seeing this screen now for a while. As a reminder, the feed there in the bottom left-hand portion of your screen, I'm talking about this one, that is live. So if you see anything on that screen, it's live, and we'll switch back over to a full screen view from the courtroom. If you hear anything from the courtroom, that's also live because we have left the audio open on this live stream. So if you see or hear anything, that is from the live feed, and we will resume our live coverage momentarily. Our streaming coverage continues on WFLA.com, the WFLA app, as well as here on YouTube Live.
Here's your letter.
Perfect.
Okay.
Folks, JB here with you live. There's some courtroom activity that you can hear. Let's go back live and go full screen. Now, the audio is going in and out, but we do have some activity at the courtroom. Not sure what this is, but we'll pay attention here closely live on WFLA Now. JB here back with you folks, and we do now have some courtroom activity. You see that Rick Escobar and others in the courtroom. Stand by for an update. Curtis Reeves back in the courtroom. As more and more people now filing in, awaiting confirmation on the announcement that is coming. Could be several different announcements. Any potential verdict we'll have for you live here on WFLA.com, the WFLA app, as well as on our social media platforms. Hey folks, JB here with you live on WFLA Now. You can see here from left to right, Rick Escobar, Dino Michaels, and Curtis Reeves, the 79-year-old on trial for second-degree murder in the shooting death of Chad Olson, 43 years old. That shooting death occurring in January of 2014, 8 years ago. Now, they have filed back into the courtroom here. We expect some kind of an update. Whether or not that update is the verdict, still, we're waiting on official word. We'll pass along, of course, any updates that we receive from the courthouse as soon as we have it. We all know that social media by now is starting to see some activity. Various reports are starting to come in. However, we're waiting on official word to present you with what this update is expected to be shortly here from the courtroom in Dade City, Florida. Going back full screen, live to the courthouse in Pasco County. Again, left to right, defense attorney Rick Escobar, also on counsel. Dino Michaels, Curtis Reeves there in the silver blazer on the right side of your screen. For those asking, is there audio? I have not touched the audio. The audio is still wide open, but remember, that's controlled by those who are there at the courthouse. So they will open and close the audio as necessary, and right now that audio clearly closed. So if anyone's asking, can we hear what they're talking about? There is no audio to bring you. It is a singular court feed coming out of the courtroom here in Pasco County, Florida. It has been 3 hours of deliberation. Deliberation beginning around 5:44 Eastern Time. The time now is now 9:04 Eastern Time. So it's been about 3 hours of deliberations, more than 3 hours now. And still, the courtroom, let's point this out, still very much largely empty, as all the courtroom attendees are still likely either in the hallway or outside the courtroom, in their cars, or returning to the courthouse if they left for a brief time awaiting word, perhaps even unofficially, that there was a verdict reached. So still the courtroom remains mostly vacant But you're looking here at Curtis Reeves and his representation here in Dade City, Florida. And now more members of the Reeves family filing back in, including Curtis's wife, Vivian Reeves, who did testify in this trial. So clearly an update expected here momentarily in the courtroom. And for those of you who haven't been covering or haven't been at a courtroom or in a courthouse for a trial of this magnitude, a lot of time, yes, word will start to get out unofficially before an official announcement is made. Again, no courtroom audio yet. There's Nicole Olson, who was there that day, and she is now reacting with quite emotion as if they are expecting a verdict. Again, awaiting official word that we have a verdict in this case. And we'll pass it along to you as soon as we have it. Our feed is frozen, and as I understand it, other feeds have frozen too out of Dade City, Florida. We're working on the signal.
Ladies and gentlemen in the audience, I appreciate your being calm and quiet participation during the last few weeks. So let's manage to do that one more time. No outbursts of any sort, and we'll bring them in. Did you get all the evidence? Okay, good.
Jurors in the courtroom, Your Honor.
All righty.
Jurors may be seated. All jurors are present and accounted for, Your Honor.
All right. Looks like juror number 2. Do you have the verdict forms? Give them to the bailiff, please. Thank you. Madam Clerk, would you please publish the verdict?
In the courts of the 6th Judicial Circuit in and for Pasco County, Florida, State of Florida versus Curtis Judson Reeves, case number 2014 CF 216 CF AXES. Information for count 1, murder in the second degree. Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all this 25th day of February 2022, juror number 2, foreperson. In the courts of the 6th Judicial Circuit in and for Pasco County, Florida, State of Florida versus Curtis Judson Reeves, case number 2014 CF 216 CF AXES. Information for count 2, aggravated battery. Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all this 25th day of February 2022, juror number 2, foreperson.
Thank you, Madam Clerk. Does counsel for either side wish to poll the jury?
We do, Your Honor.
All right, ladies and gentlemen, at this time, the deputy clerk will poll the jury. That simply means that she will ask each of you individually if the verdict she read is your verdict. If it is, you need only answer yes. If it is not, of course, you should answer no. Madam Clerk, will you please poll the jury?
Juror number 1, is this your verdict?
Yes.
Juror number 2, is this your verdict?
Yes.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Yes.
Juror number 6, is this your verdict?
Yes.
Thank you, Madam Clerk. All right, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are now, or will be in a moment, once I say the magic words, you are at liberty to speak with anyone about your deliberations. You are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. So, on behalf of the state of Florida and everyone here, I want to thank you from the bottom of my heart for your long enduring service during this difficult case. You guys have been real troopers. It's been a long few weeks, and I want to thank you for performing the job that you have just done, and I hope you didn't find it too burdensome and you'll be willing to do the job again when the call comes. You're definitely good for at least a year, though. So at this time, I will now discharge you from your service as jurors, and you are free to go. Thank you, ladies and gentlemen. Grab your phones. Grab your phones. Did he get his phone?
Yes,
Did he? Okay. Okay.
All right,
Live coverage continues on WFLA Now after the court proceedings.
jury is out. Is it anybody?
All right, Mr. Reeves, the jury having returned a verdict of not guilty as to count 1 and count 2, you are free to go. Congratulations, everyone. Thank you for a wonderful time. Good luck.
Breaking news on WFLA Now. Here's J.B. Buno.
Curtis Reeves, not guilty in Pasco County Court of second-degree murder and aggravated battery. for the 2014 shooting death of Chad Olson in a Wesley Chapel movie theater in a dispute that occurred over texting. Curtis Reeves being embraced by members of his family, his closest friends, those who have been here supporting him in court. On the other side of the courtroom, Nicole Olson, emotional as she leaves the courtroom.
Let's go. You ready?
Continuing our coverage here live, everybody, on WFLA Now. JB Buno here with you live, and our streaming coverage continues. We are expecting to hear reaction in interviews after everybody filters out of the courtroom here. So if you want to hear reaction, we're expecting to hear it perhaps on both sides, from attorneys and perhaps members of the family. Stick around. Let's go back live to Dade City, Florida. Curtis Reeves,
Yes, I did get your order, thank you.
with a look of relief on his face, after 8 years, waiting to hear the words, not guilty, and he got it twice. Not guilty on second-degree murder. Not guilty on aggravated battery. His team of attorneys arguing self-defense. Now the courtroom audio coming back. Let's listen. If you've been with us here on Facebook Live, YouTube Live over the course of this 2-week trial, you might have formed an opinion of whether you thought Curtis Reeves was guilty of murdering Chad Olson that day in January 2014 when he pulled out his handgun and shot him in the chest during the previews of a Monday matinee. Some of you might have felt that he was not guilty, acting in self-defense when Chad Olson turned around in his seat, threw popcorn in his face. Regardless of how you feel between guilty or not guilty, you can't deny that it was an emotional gut punch in this courtroom on both sides. One side, the outcome that they had waited for 8 years. The other side, the outcome that they had feared for 8 years. And this here on your screen is the winning side. Curtis Reeves found not guilty, and you can see in his face gratitude. He's talking there with Rick Escobar, defense attorney, who spent 3 hours in his closing arguments earlier today. Also there, Dino Michaels, major part of the case as well. We're going to be going over your reaction from Facebook Live, YouTube Live, in the comment section. We're live on hashtag AJB on WFLA Now. We're going to be featuring your reaction if you use that hashtag. I know that so many in the Tampa Bay area, so many across the state of Florida you've been following this story for 8 years when it was unsuccessfully attempted to be tried as a stand your ground case. That determination coming down in 2017, getting to the point here where Curtis Reeves was to be tried for second-degree murder, and now walking out free. Again, we do expect to have coverage, folks, from outside of the courtroom, where we're expected to hear from attorneys. Making closing arguments today was Scott Rosenwasser. He is the attorney with the prosecution. We also have Rick Escobar, who represents the defense, and we're expecting to hear the reaction from both sides, as well as members of the family as well. JB here with you live, folks, on WFLA Now. And Nicole Olson, Chad Olson's wife, who was shot in the hand that day. Her hand, the middle point, if you will, or she had her hand on Chad Olson as the bullet came from the gun of Curtis Reeves, traveling in her husband's direction It would strike her in the finger, injuring her hand, but it would be a fatal gunshot wound for Chad Olson, 43 years old that day, when he died in the Wesley Chapel movie theater. Again, a dispute that occurred all over texting. Let's get to some of the comments, everybody, on WFLA Now. And I'm going to monitor our live feeds. This is what we do as far as monitoring, as we take a look at some of the video from the trial. We're going to be monitoring the live feeds and trying to bring up any shots of podiums or microphones or interviews as they happen. So we'll try our very best to bring you those the moment that they begin. But you'll have to excuse, I'm sure, both sides as they are just processing this news. If it's been 8 years, the very least that they're going to ask for is just 8 minutes to just sit down and process what has just transpired with a 6-person jury finding Curtis Reeves not guilty on both of the counts, those counts being second-degree murder as well as aggravated battery. We're going to feature some of the comments here, everybody, on WFLA Now. You can use hashtag HeyJB to give us your reaction. And I'm going to be honest, I'm really looking for the reaction for those in the Tampa Bay area, those who've been following this story, those who every time you drive by that movie theater, you say, that's where the Curtis Reeves shooting happened, or that's where the Chad Olson shooting happened. People in this community have been waiting for what was going to be the resolution of this case for nearly a decade. And so I'm really hoping to hear from some of the folks in our community here in Tampa Bay. And you can use hashtag HeyJB to perhaps give us a little bit of insight as to what you were feeling when you heard of this story 8 years ago and what your reaction is now in the aftermath of the verdict being read aloud that Curtis Reeves is being found not guilty. I'll get to some of the comments in the Facebook Live comments section. And let's start here, and I'm looking. Yeah, I'm seeing a lot of comments, and they're scrolling in so fast. We're going to try to pluck them as quickly as we can. They're coming in extremely fast. But again, to explain how the system works, if you'd like to have your voice heard or to ask a question, you can use hashtag HeyJB. If you don't want your comment and your profile picture and everything featured on a news broadcast, just don't use the hashtag. We'll let your comments scroll on by, and you can continue commenting back and forth with your fellow viewers here on WFLA Now. All right, let's get to some of the comments. I think a lot of the comments are really focused on Nicole Olson, who we've been seeing video of, cutaway shots of, really since day one of the trial. Echo Love saying hashtag HeyJB, prayers for Nicole and her daughter. And Echo saying here, sorry, the system failed you. So Echo, one of our commenters who believes that this is not the right verdict. And those, listen, if you've been following this case, as far as the trial from last Monday when it began, you're best equipped to form an opinion on whether or not you feel the verdict was correct, because if you've been following it from day one, you have heard a lot of the evidence, you've heard the testimony, as I just pay attention to our feeds. Michelle Hernandez, hashtag HeyJB. I'm in Tampa, and I remember this well. Today is a sad day. No justice, or I think it's no justice, no peace, is the comment here from Michelle Hernandez. Get to some other comments. Again, this is what we're doing. We're going to feature some of your reaction as we await the real reaction from Dade City. Again, we're expecting interviews to take place with attorneys from both sides, as well as perhaps family members as well. Will Nicole Olson be able to speak in the aftermath of hearing not guilty, not guilty? We're going to find out. We had heard that she was planning to speak after a verdict was read. She wanted her voice to be heard. But will Nicole Olson, now that it has actually arrived, this verdict, is she going to be able to speak, losing her husband at the young age of 43 years old? I'm going to look for some more comments with our hashtag system here. And again, monitoring the feeds, because I know everyone is here to hear the reaction from the courtroom, and we'll try to get to as many as possible. There's an opinion here from Stephanie Thompson. Oh wait, Stephanie, I'll get to your comment. I will, Shannon talking about self-defense, as we now have official cutout audio from the courtroom feed. That's what that beep was. Shannon, I'm going to get to your question about the defense argument and the self-defense argument. We're going to kind of lay that out for you because that's the reason why we have a not guilty verdict. So we're going to talk about the case that was presented by Rick Escobar and his team. Going to read a few, pluck a couple more. I also heard that as well, Megan. I think that might have been a Freudian slip, but well, you know what? Let's start with that. Megan O'Neill, I have to admit, I thought it was a little bizarre as well. Megan O'Neill saying #KJB, the judge butchered her words at the end. That was just sickening. No death is worthy of that. Yeah, I think Judge Susan Bathel said something to the effect of, I hope you had a wonderful time. It was so, I got to be honest, it was so jarring that I thought to myself, is this a murder trial? I too, I don't want to put words into her mouth until I hear it back, but I'm not remembering exactly word for word what she said for an exact quote for you, because it was just very bizarre to hear that come from the mouth of a judge during a murder trial. But I've seen a bunch of comments, people saying, well, that was very bizarre etiquette by the judge in this case. Shannon Ann, what was the gist of his defense? It can't be that he was afraid of popcorn. The gist of the defense was that Curtis Reeves was struck either by a fist or by a cell phone, and that he was in fear for his life due to an escalated amount of behavior from Chad Olson in the row in front of him in that movie theater. The flash of light that you see in the surveillance video, it was brought up time and time again as to whether or not that was, in fact, a cell phone, or whether or not that was the reflective material on Curtis Reeves' sneaker, and whether or not that played a key factor in this case. We talked about it after the jury began deliberations, where I said that could potentially be the most key question in this case, whether or not the jury thought that reflection of light in the surveillance footage was that of a cell phone that struck Mr. Reeves, or whether or not that really was his sneaker as he kind of moved in his seat. The jurors themselves know, but after about 3+ hours of deliberating, they were able to unanimously come to this verdict of not guilty. Yeah, so Carol, I want to go back to the just go back to the judge here for just a second, because this is what I heard too. Carol Ellison, #KJB, the judge thanked everyone for a wonderful time. Yeah, it's I've covered a lot of murder cases. That's not one that I've ever heard. I have to be honest, and I know that it's grueling work to be in a courtroom and hear these facts, and extended hours, and this has been going on since really around 8 a.m. this morning when everyone arrived for the day. It's been a long day in court, but I have to pass along. I've never heard those being the final words in a court proceeding from a judge in a murder trial. That's new for me. Michael Boardman, #HeyJB, says excellent verdict. There were many who called for this as an exercise in legal proceedings for how to defend a self-defense case, self-defense incident in the state of Florida. People who felt that this was the only verdict from the beginning, and people who have been commenting at me on Facebook and YouTube saying that this is going to be not guilty, that the evidence in this case just doesn't add up to the charges that were presented. And with that, Stephanie Thompson says, #KJB, I think that they overreached by charging with second-degree murder. Might have been found guilty if the state went for voluntary manslaughter. Were the charges appropriate? These are now legal questions that legal analysts are going to have to delve in on, and we're going to have additional coverage in the days ahead on WFLA.com about the interpretation of this decision and this verdict by the 6-member jury here in Pasco County. Again, for those of you just joining us, we are waiting for a feed outside of the courtroom, and that feed is expected to bring us reaction from the attorneys that you're seeing here and replayed footage from the last several days. Rick Escobar, Dino Michaels, I'm sure are going to be elated to walk up in front of the microphone and have their moment of victory as they successfully defended their client, Curtis Reeves, a decorated Tampa Bay law enforcement veteran and retiree. Let's get to some other hashtag HJB comments as we wait for that feed to become available to us. Laura, I see your comment with hashtag HJB. We'll bring that one up. And seeing some others come in here on YouTube, on Facebook as well. And we'll see. Yeah, all right. Yeah, Paul will bring up your comment. Yeah, Courtney, I think that you're right too. All these comments that I'm just getting them ready in the queue here, folks, to bring them up. Okay, that's a pretty honest assessment of the judge. We'll get to your comment, Matthew. And Nikita, we're going to get to yours as well. All right, let's bring up some of the new comments that have just come in. Again, Carol was, yeah, Carol, I heard this right too. And I just want to play it back for a moment. Maybe I can. Maybe there's an opportunity for me to play it back if I can. And we can hear the judge's words. We'll have to do that. I'll have to find the exact moment, the exact time code. But yeah, it was something to the effect of thanking everybody for a wonderful time, as Carol's noting here, and I'm noting here as well. I think we heard about the same thing. Yeah, a little. It's kind of you know, it's kind of secondary, obviously, to the subject matter at hand that we have. Curtis Reeves being found not guilty on both charges. That, of course, is the big news from this. But I understand social media is going to grab on to irregularities, and this is as irregular as anything you'll ever see from a judge in a murder trial. It's pretty out there. Let's get to some of the other comments that came in there afterwards. He, Alex, Carol, hashtag AJB. Yes, the judge's words were shocking. Others are saying this too, that the judge's words were just quite bizarre. Laura Jeffers, hashtag AJB murder, who got away with it? How unjust. One of the opinions from one of our commenters here on WFLA Now's Facebook Live comment section. We're also plucking some comments at a YouTube Live as well. Paula Coffer, hashtag AJB, the prosecution theory that Reeves killed a man because he was mad that he had popcorn tossed on him just wasn't believable. Courtney Scott, hashtag HeyJB. I agree with the odd closing words from the judge. It had been a long day and maybe just an awkward slip while trying to find the right words. Yeah. Sure. Yeah, I think this is right. Because you say you have a wonderful time after a pleasant meal or, going out with friends. Kind of strange in that moment that we heard that from Judge Susan Barthel. Matthew Cherry, hashtag AJB. It was the right verdict, even though the judge didn't seem like she knew what she was doing. Again, this could have been, this is an opinion from one of our commenters. It could have been mental fatigue accruing in that moment. But Matthew Cherry seems to not be really in favor of the judge in this particular case. Nikita Hamilton, hashtag AJB. Are we setting a bad precedent with this verdict? I'll leave this for our commenters to determine. This is why we're live on WFLA Now, to have these conversations in the aftermath of significantly groundbreaking sort of news for the Tampa Bay area. And now I say groundbreaking because it is sort of breaking ground in the conversation of self-defense cases here in the state of Florida. Is this case now going to be in the textbooks? Is this case going to be referenced in countless other future self-defense cases? Are they going to look at Florida versus Reeves in the future and say, this is what happened, these are the facts of the case, this man was found not guilty? And is that going to establish precedent, legal precedent, for future court proceedings involving murder, manslaughter, and basically terrible acts of crime in our state? It's a fascinating question, and one that I'll let our commenters kind of come in on, and feel free to comment at us and continue the conversation as we await any feeds from outside the courtroom. There's no feeds right now, and the reason that there are no feeds is because this is just again news that is 8 years in the making, and I think everyone is just taking a moment to process everything that has transpired. I'm going to step away for 30 seconds to get an update on the actual status of any post-verdict press conferences taking place in Dade City outside the courthouse. Back in 30.
Breaking news on WFLA Now. Here's JB Buno.
Curtis Reeves being found not guilty on all charges. Second-degree murder, aggravated battery. As now reaction expected to come in here shortly. 8 years after the shooting death of Chad Olson in a Wesley Chapel movie theater. Hey folks, JB back here with you, just conferring with our team to get things kind of straightened away. And we do hope to have reaction here for you at some point. There is no imminent press conference because everyone is still reeling and grappling with this news, depending on what side that, you're on. You're either elated with relief and joy that the jury came to this verdict, or you're shocked and potentially maybe emotionally crippled from this news, if especially you're with the Olson family, because this is not the news that you had wanted in seeing this over the last 8 years. Think about where you were in your life 8 years ago. That's how long it's been between the act that we're talking about, that movie theater shooting that claimed Chad Olson's life, and the verdict, the resolution, the awaiting justice for those in the Olson family. That's 8 years, or awaiting exoneration for those in the Reeves family. So we're anticipating some courtroom reaction here, or courthouse reaction here soon, but let's get back to some of the comments that are coming in, everybody, on WFLA Now. I know that there's a lot of folks with questions, a lot of folks that want their voice to be heard, and we'll continue to go over some of the comments. All right, using hashtag AJB, we can feature your comment. Tracy, you're up next. We'll get to Tracy's comment momentarily. Deanna, we're going to get to your comment as well. Let's start with those two. Tracy Fender, hashtag AJB. This was the right verdict. Everyone has the blank to protect their life. Rick and Dino did a phenomenal job. This man has been on house arrest for 8 years. It's a tragedy. Someone had to die. No one won in this situation. Folks, give me just 1 second. I think we're going to be bringing in some legal expertise here, folks, to help break down the really the aftermath of this decision, and going back to this comment from Nikita, the precedent that this sets in Florida, how this impacts self-defense cases in Florida. I'm going to be very curious to hear from our guest, whom we anticipate shortly on WFLA Now. Deanna Lynn, #HJB. I am in complete shock. I did not think it was proven that this was self-defense, and I can't believe the judge said congratulations at the end. Yeah, we're all stored. I think a lot of us are just. Did we all hear that from the judge? It's just, again, just kind of odd etiquette. And other commenters have brought up whether that was just a result of mental fatigue and mental grind, but I can't deny that still so many of our commenters are talking about the choice of words by the judge. We're going to be joined here, folks, in just a moment by Bryant Camareno of Camareno Law here in the Tampa Bay area. He has been on both sides of the courtroom as far as being a prosecutor and as far as being a criminal defense attorney. I'm very curious to hear what Bryant has to say. He'll be joining us in just a few moments. Let's get to some of the other comments that are coming in. And I'm seeing a lot of comments. Okay. Yeah, I think that there's just, the number one comment that I'm seeing, at least with #HJB, is just the fact that 10-4. The fact that, the judge's words are still, people are still processing that, because again, it's just, and my job here, let me explain. My job here is to be a reflection of what you're saying in the social media comment section, to kind of give folks an idea as to what the temperature is on a particular news story and how people feel in response to a news story. And in addition to that, answer questions and be a information resource for you. I can't help but point out that there's just a ton of comments about the judge's final comments in this court proceeding, in this murder trial, and a lot of folks are just pointing out that it was bizarre and highly irregular. Got it. Okay. All right. We've got reaction from the courthouse. Let's go back live. Let's listen in.
This is a day that's long been coming. I will tell you that these moments are the greatest moments, not only for my client, obviously, but for the great team of lawyers that I had on this case. Dino Michaels, who's done just a phenomenal job in this trial. Where's Karina? And Matt Funderburg. These are lawyers that worked tirelessly for us. I can't tell you the number of hours that they've poured to this case. And I think this victory, this acquittal, sends a message out to the community. And that message is that you can't abuse the elderly. And we believed all along that Mr. Reeves that day was attacked in that theater, and he did the right thing in defending himself. I know he looks forward to a wonderful retirement, or continue of your retirement, and I can't tell you how happy we all are. We were confident, and let me tell you, all the talking heads from Court TV who indicated we were never going to win, for all my colleagues in Hillsborough County that likewise gave us no chance. Here we are. We're at the steps of victory, and Mr. Reeves is a free man, which is the most important.
Mr. Reeves, what does that freedom mean to you now?
This is great. It's been a long 8 years, and I couldn't wait for it to be over with. I'm very proud of my team of lawyers here that did a fantastic job in bringing out the truth, and hopefully you guys will put the truth in the papers for a change.
You certainly have been through a lot over the last 8 years. What was it like having to wait that long to get to this day?
It was very trying, not just for me, but for my family as well. So it was a tough time for all of us, and with the restrictions and all the things that went on over the years, it was very difficult to deal with.
And you've certainly sat through your share of trials as a law enforcement officer. You've been there. What was it like to be on the other side?
It was a completely different ballgame and something that I've never encountered, and hopefully I never will again.
Thank you, Mr. Martin.
And when you heard not guilty, what was the first thing that went to your mind?
I'm not sure anything's gone to it just yet, but I'm working on it.
And hard to ignore the Olsons walking out visibly upset. Anything you would say to them?
It was a sad day for everybody on both sides. It never should have happened. I never wanted it to happen. I never planned for it. I never even in my wildest dreams ever thought anything like this would ever happen. And it, like I say, I feel as touching for them as I do for my own family.
Thank you all.
Thank you.
Thank you. Thank you very much.
Let's go. Yes.
Got it. I got it.
It's a little harder to see and walk them so
What? Tell me that car. So he was asking for team coverage at this point. You know, I mean, I'm
Go home. I got it.
we're pretty proud.
You know, I said, give me the car. I'll go put the package together. I can handle a verdict. It's not my first rodeo.
So I'm going to take 19 home tonight because 11 is just crowded.
Yeah, is that okay? Jeff, were you in the courtroom or did you?
No,
No, that's.
Breaking news on WFLA Now. Here's J.B. Buno.
Curtis Reeves, there in court. Curtis Reeves walking out a free man. And you heard his comments and a little bit from the victorious side of the courtroom as Curtis Reeves found not guilty on all charges. JB here with you live, everybody, on WFLA Now. Really looking forward to hearing from Bryant Camerino, who's coming on next here, everybody, on WFLA Now. In fact, why don't we bring in Mr. Camerino? Bryant, good to have you back on WFLA Now. Good to see you. Your reaction to this case, really want to hear from you as a legal expert here in the Tampa Bay area. Is this the verdict that you were expecting? What was your initial reaction to the news coming in that Curtis Reeves found not guilty on both charges?
You know, I think that whenever there's an acquittal on a murder trial, I think there's always a state of shock from spectators and observers. But there's also this element that I attribute the acquittal to three things that the defense team did. Number one, when they laid the foundation through one of the their own experts.
This meeting is being recorded.
That one of the law enforcement, that law enforcement failed to pursue certain investigative leads, like recreate the crime scene, recreate the lighting conditions. So that was number one. Number two was when Mr. Reeves himself testified, and I think he showed the jurors that he was, an elderly person who was not the hothead that the prosecution was trying to make him out to be. And then, of course, the closing arguments, where Mr. Escobar spent nearly over almost 3 hours laying the foundation that that Mr. Reeves had an exemplary record as a law enforcement officer, as a security officer at Busch Gardens, without any evidence that he was the hothead, again, that the prosecution was trying to lay. So yes, did it come as a shock? I think whenever there's an acquittal, there's always a state of shock. But at the same time, no real surprise, because again, the defense team did such a great job of laying a foundation that Mr. Reeves was not the hothead that the state made him out to be. So I think it was a great trial and a great defense tactic. And so I think that congratulations are in order.
Let me ask you this question, Bryant. Did the defense, in your opinion, win this case, or did the prosecutors lose it?
No, I think the defense won the case. The prosecution had everything that they need. I mean, they had everything they needed to convict. They had the video, they had eyewitness testimony. So it's just unfortunate for the state, Mr. Reeves came across as a likable person. And again, I think that Mr. Escobar's closing argument, emphasizing this lack of a record of a hothead cop that the prosecution was trying to make it out to be.
So no, I think that the state did the best they could with what they had, but the defense won this through and through just with their tactic. It was a great strategy. Again, pointing out absence of lack of evidence and lack of investigative pursuit of, the fact that he pursued every lead, putting Mr. Reeves on the stand, and the closing arguments. Again, I think even though some of the people were commenting saying it was way too long, Mr. Escobar is correct. He had to hit you only get one shot at this. So he had to hit every detail, and he did a very effective job of doing so.
So when jurors are deliberating and discussing this, and they did so, Bryant, for more than 3 hours, what do you think is the number one thing that they are pointing to in the deliberation room as the reason that they came to the conclusion of not guilty as the verdict?
I mean, I think it's clear that, the jurors are told sympathy is not something they can consider. There's no doubt that they sympathize with the victim's wife. There's no doubt. And there's no doubt that they sympathize with Curtis Reeves' family. So I think they ignored all that the way they should have and looked at the absence of any evidence to support that Mr. Reeves was this hothead, looking for trouble, went out there trying to start a fight so that he could end up using his gun. And one of the other things that Mr. Escobar hit the nail on the head was he is allowed to carry a firearm as a retired law enforcement officer. In fact, the law says he should carry. So again, this is not a young kid, a young punk going out there looking for trouble, looking for a reason to use the gun. He just happened to have the gun, and the jurors believed that objectively, Mr. Reeves felt his life was in danger. The jury believed it, and so again, kudos to the defense for highlighting that.
So many commenters, and that we're live streaming, and we're live on Facebook, we're live on YouTube, and there's a lot of folks watching right now asking questions. But as the trial played out, one of the questions that was asked repeatedly was, why is there, and you're one of the best equipped to answer this question, why is so much being played into his decorated law enforcement career? This is somebody who has really a sterling resume when it comes to the many, many years that he devoted to serving the Tampa Bay area, to serving Tampa police, and to serving the people of his community as a law enforcement officer, even going as far to train other officers, even going as far to help in the early stages of the first SWAT teams here in the Tampa Bay area with Tampa police. And there were a lot of folks that were saying, Bryant, in our comment section, saying, why is so much being made about his decorated law enforcement career from decades ago, when really it's the actions of how he carried himself in court that day that should really be examined and put under the microscope? Do you think that developing this, the backstory and his history as a decorated law enforcement officer played a role in the jury's decision here tonight?
Absolutely. So, and we also have to look at one other thing. This is a Pasco County jury. Okay, this is the Pasco County, made up of people that are mainly retirees. I'm not sure what the makeup was of these jurors, but from what sources were telling me, most of these jurors had concealed weapons or were weapon owners themselves. So if they had weapons themselves, then I think they felt the need, there could be a need at some point to defend themselves. Now, so with that mindset, you've got jurors that believe in the right to bear arms. Any other jurisdiction, any other county may not have had the same mindset. That's number one. Number two, yes, absolutely. The fact that he is a decorated law enforcement officer, these are law-abiding citizens that are serving as jurors that have sworn to both uphold the law and abide by the law. So I think they looked at him, Mr. Reeves, as someone who was their protector at some point during his younger years. He protected their community, and they looked at that. So I think absolutely, by overplaying his exemplary record, the fact that he was a trainer, I think the jurors looked at him and said, hey, this is a guy that used to protect us, and perhaps, again, without looking at sympathy, and perhaps what he did that day may have been wrong, but not necessarily illegal. And I think that that's what the jurors, absolutely, his record had to come into play. Again, this was not some young, for lack of a better description, punk who's out there with a gun illegally looking for trouble. This is a man who took his family to watch a movie, and unfortunately, somebody died. We're not taking that away from what happened, but the facts did not meet the law the way the jury was instructed.
Let's flip it around and now talk about the other side, Bryant. We're talking about the Olson family. I'm not sure if you were watching in the moment when they had the cutaway shot of Nicole Olson, who visibly shaking, visibly emotionally distraught. And there are going to be those who are asking a very, very important question on what is there justice for Chad Olson? What the family has been waiting 8 years to get this verdict. What is it like for the Olson family tonight when they feel, in their estimation, that the legal system failed them because they didn't hit on the second-degree murder charge, they didn't hit on the aggravated battery charge, no charges, and we have Curtis Reeves walking out as a free person when they have to go home, and the 43-year-old husband to Nicole, Chad Olson, 43 8 years ago, he would have been 51 now, he's not there. You have one man who's there who gets to enjoy the rest of his life being 79 years old, while the other side has to deal now with this grief of knowing that he was shot in a movie theater one day and he's no longer with us, and that there was no one, and there was no charge or anything that's stuck in a court of law that is justice to them.
You know, I have no doubt, I can tell you right now, I have no doubt that they sympathized with her. There's no question about that. And the fact that they took 3 hours, I guarantee you they read through those jury instructions and emphasized and reminded them sympathy is not a factor here. But there was something that Mr. Escobar said in his closing arguments. He threw out this concept that this perhaps should belong in a civil courtroom. I don't know if anybody caught that. I caught it. And if the jurors caught it, you know, there's different types of justice. You know, there's justice in terms of punishment against Mr. Reeves. And unfortunately, you know, some people call it there's cash justice. I'm not in any way suggesting that the Olson family was looking for money out of this. But I wouldn't doubt that the jurors thought to themselves, look, there is another courtroom, there is another venue where there can be remedy, just like in the O.J. Simpson case, acquitted in the criminal case, but found guilty in the civil case. And so I wouldn't be surprised if the jurors thought to themselves, look, he didn't commit a crime, but there's other forms of justice that maybe another jury in another venue and another judge might make her whole. And even though you can never replace someone, a loved one, with money, I can almost safely assume that had to have come into play in their deliberation as they read the instructions, but also keeping in mind again that Mr. Escobar brought this up and he planted that seed effectively. And I wouldn't be surprised if the jurors thought to themselves, hey, there's other venues here, but for right here, right now, before us, he's not guilty of the crime that's been presented by this prosecution.
Let's get to some of the questions that have come in from our social media audience. Brian, we brought up a couple of these on our live stream, and I want to go back to a couple of the ones where I said, wow, it would be really great to have you know, some legal analysis on this question. Let's go to Nikita Hamilton's question that we had up earlier, and she asked, are we setting a bad precedent with this verdict? I'm going to ask you this. I mean, this is a question that, from her opinion, is a bad precedent. I'm just going to ask this question to you just straightforward from a legal perspective, and just strike out the word bad for a second. And Nikita, sure. It's because I want to ask it to Brian as objectively as possible. And Nikita would then be asking, are we setting a precedent with this verdict? Does this have now legal ramifications going forward on other cases here in the state of Florida? Is it just Pasco County? Will other cases in Florida point to this case in the future? How does this alter other self-defense cases going forward in the Sunshine State, Brian?
I think the answer is no. It's not going to set any precedents at all. And the reason is each case is different. Each factual basis is different. You're not going to have a 71-year-old man, retired police officer with an exemplary record, doing this every day. I don't see that happening. So, and there are shooting cases every day. You can walk into almost any county, any courtroom in the state of Florida, and there's always a shooting case. Some are acquitted and some are convicted. And it just so happened that this fact pattern with this jury, again, in Pasco County, with most of them, again, without knowing the makeup, most of these are retirees from other counties, other states. I don't think it's going to set a precedent at all. I think what it will do, though, is it will send a message to gun owners. Listen, do we want to be in the position that Mr. Reeves was in and fight a case for 3, 4, 5, 6, or in this case, 8 years and possibly face 25 to life? Do we want to be in this position? I think, if anything, the opposite. I think gun owners are going to think very carefully before they use their weapons. So I think it may have a positive effect because nobody wants to be in the position that Mr. Reeves was in. So I think it's quite the opposite.
Let's get to another one of our comments from earlier from Deanna Lynn Bryant. She said, hashtag HJB, I'm in complete shock. I did not think that it was proven that this was self-defense, and I can't believe the judge said congratulations at the end. We're gonna play back that moment here in just a second, but I want to go back to Deanna saying, I did not think it was proven that this was self-defense. What's your reaction to that, just the self-defense component of this particular trial?
All right, good. That's a great question. So she's right in the sense that if the defense team asserts an affirmative defense, entrapment or self-defense, the burden is on the defense to prove, again, whatever that affirmative defense is, in this case, self-defense. So it's possible that the jury didn't believe self-defense, but quite frankly, without interviewing the jurors, we're not sure what their mindset was. You guys may have heard of jury pardons, jury nullification. It's possible that the jury said, you know what, I don't necessarily think it was self-defense, but I also don't think that he committed a crime. So it's possible that they weren't mutually exclusive, meaning it's possible they didn't think it was self-defense, they just didn't think that he committed a crime. And so it's without interviewing these jurors, it's really hard to tell, whether or not they actually believed he was defending himself, or they just thought the state has not proven the crime. Because again, if you assert affirmative defense, then it's up to the state to rebut that and show that it wasn't self-defense. But it's hard to tell, hard to answer that question without interviewing the jurors, and maybe one day they'll come forward and answer that question. But it's possible they just thought, no, we don't think there was a crime here, and we still don't think it was self-defense. It just wasn't a crime, and then they just found not guilty.
Let's go now to the second part of this comment from Deanna. And Brian, I don't know if you heard it, the final words from Judge Susan Barthel in this case, but she said, and others, we had just a high volume of comments about Judge Barthel's parting words with the courtroom, and kind of it was unsettling to some people. And I noted too that some of her parting commentary was a little strange. I found it on my phone. It's a bit easier to scrub through on a phone than it is to find it on our system here, because we're dealing with so much footage at all times. So I'm going to play it back on my cell phone this moment. I want everyone to listen, including you, Bryant, and just tell me what you make of the judge's final words here in the courtroom.
Free to go. Congratulations, everyone. Thank you for a wonderful time. Good luck.
What do you make of that, Bryant?
Okay, I can tell you right now, I've tried 217 jury trials, and I've never seen a judge not congratulate both sides. And in this case, she actually says it, congratulations, and I think I forgot how she phrased it. I don't think it was congratulations to just Mr. Reeves. I've known Judge Barthel for many years. I think she's one of the better judges to have. I think she's very fair-minded. So number one, the congratulation aspect, I think that it's not unusual. Judges do it all the time. In fact, sometimes they go out of the way to say, thank you to both sides for being professionals and so forth. So the congratulation part, I didn't have a problem with it because, again, it looks like it was directed to both sides. Now, the good luck, again, I think just good luck, whether she was directing it to Mr. Reeves or to both sides, that's hard to tell. But I don't think it's unprofessional for the judge to have made that comment because, again, she's a human being, and I think she was really complimenting the hard work that both sides put into the case.
Bryant Camerano joining us here, everybody, on WFLA Now. If you have any questions, you can use the hashtag you see on the right side of your screen. You can use hashtag Hey Bryant, and we'll try to bring up a couple of comments for, I think we'll have Bryant for about another 10 or so minutes before we have to let him get to it. But Bryant, what are some other observations that you made over the course of this trial? I'd like to ask you about the surveillance footage, and I don't know if you saw the reflection in the footage about whether or not, now Curtis Reeves, center of your screen there, has said that he was struck with a cell phone, and there was evidence brought forth as to whether or not that was the phone being reflected in the surveillance video, or whether or not that was reflective material on his shoe. Where does that component of the trial come in your estimation?
Well, I think that there may have been some doubt, reasonable doubt, as to whether or not an object was actually thrown. There was one, as you may recall, there was testimony that his glasses were askew. And I think Mr. Reeves may have used those exact words, and there may have been redness in one of his eyes. And so at some point, something did make contact with Mr. Reeves. So I think there was reasonable doubt. I think the state tried to emphasize it was not a phone. There would have been much more damage. but something did make contact with Mr. Reeves. Now, whether it was, his own hands, someone else's hands, but there was undisputed, unrebutted testimony that his glasses were askew and they had red mark in one of his eyes. So something happened. So I think the jurors were looking at this idea that I don't think the jurors were looking so much that he was actually hit. It's the perception that he could have been hit or that he could have been attacked by these other means, fists, through other physical confrontation. So I think that the idea about this phone being the weapon, I think that was thrown out there. I don't know if the jurors were convinced he was actually attacked by the phone. I think they were more convinced that Mr. Reeves' perception was that this gentleman is standing up, he's 6 feet tall, he's hovering and looming over me. That's, I think, what the jurors were looking at. And again, without knowing, did they feel he was defending himself, or did they just feel that he didn't meet the elements of manslaughter or second-degree murder? I think that that's really what the jurors were looking at, not so much the phone. I think there was doubt as to what happened, but there's no question that something did happen, again, for the glasses to be askew and to have some redness in one of his eyes.
Let's get to the number one comment. When I asked for questions, Bryant, the comment section lit up for questions for you, and there's really one that people are asking about more than any other, and it is going back to Judge Barthel's parting words there in the courtroom, and addressing the part where she said, quote unquote, about a wonderful time. Would you mind if I played it back here for you one more time, and maybe you can address
sure.
it?
And I do. You refresh my recollection. But go ahead.
Yeah. Let's play back again.
Verdict of not guilty as to count 1 and count 2. You are free to go. Congratulations, everyone. Thank you for a wonderful time.
Wonderful time. Our commenters want to hear from you about that choice of words there by the judge.
Understood. And you know what? And I forgot to bring that up. And so, listen, again, bad choice of words. Judge Barthel is an excellent judge, been on the bench for many, many, many years. But I can tell you right now, this was an exciting trial to watch. Even someone with in my case, 28 years of experience, and many of my colleagues with just as much, if not more experience, were just as fascinated by the trial. And the judge, again, perhaps poor choice of words, but it's sad that somebody died, but it was a source of entertainment. I'm not saying it was a source of entertainment for Judge Barthel, but I think her bad choice of words, but she made it, I think that she's complimenting both parties for making it such a pleasant experience. And again, I can't read her mind, but this could have been a much uglier trial. I've seen parties go at it toe to toe, and these guys were at it. I mean, both sides were at it, but they kept it civilized. So I just think that that's what she meant by that. It was a wonderful in the sense that it could have been such a much more contentious trial, like many of us have lived or experienced. I think that's what she meant by that. And I just think it was just a poor choice of words, especially when you have someone who, on the losing side, someone who lost their family members. Yeah, I can understand why they might be offended by that, but I don't believe the judge meant to offend anyone at all.
That's what I was going to ask you, is if you're Nicole Olson and you just heard this news and you're emotionally distraught and you're hearing it described as a quote unquote wonderful time by the judge, I think that there are many out there who would call that, salt in the wound, a very, very fresh wound that she has just learned. There has to be a losing side in a particular, case like this. And in this case, we see Chad Olson's wife just shaking in just an emotional overload in that moment. So let's just kind of talk about this now, going forward. Is the Curtis Reeves trial over? He walks out a free man. Is there any other legal options now for the state? Is there anything going forward? What is the aftermath of this verdict in your estimation, Bryant?
Yeah, as far as, Mr. Reeves is concerned, under the Constitution, double jeopardy, he's done. The state's not going to be able to do anything with him. I can't think of anything creative they can do to come up with to try to come after him again. As far as the families, the Olson family, they have an excellent lawyer working with them, TJ Grimaldi, great lawyer. I've known him for many years as well. So there may have been, again, there may be a civil aspect to this as well. I haven't spoken to him on that issue. So as far as Mr. Reeves, he is unfortunately, or from his point of view, fortunately, unfortunately for the victims side, he gets to move on with his life, and that's the end of that. As far as the Olson family, I think their next pursuit is going to be civil action. But again, that's never going to bring back her husband. the father of her children, and that's the sad part. So, but to answer your specific question, that's the end. I don't think we'll hear much from Mr. Reeves. I think he'll move on and enjoy the rest of his life in retirement, and then and that'll be the end of that as far as Mr. Reeves is concerned.
Bryant, you've tried and you've been part of countless thousands of cases, correct? I mean, thousands of cases in the Tampa Bay area. You've been on with us before. You have been on WFLA News Channel 8 with us before many, many times. You've tried a lot of cases in this area, and I just want to hear from you before we let you go. And we appreciate you taking some time out of your Friday night to join us here and provide us with some analysis. But when you look back and people bring up this case to you in weeks from now, months from now, years from now, what's the biggest takeaway in your estimation from this case, the Curtis Reeves trial, Florida versus Reeves?
If you're a gun owner, please, I am not a gun owner. I don't know. I don't have a concealed weapons permit. I don't know, what it's like to have to possess a gun. I've shot guns before when I was a probation officer decades ago. I think the biggest lesson to anyone who's watching this, listening to this, if you're a gun owner, be responsible. I didn't, again, if it says you're prohibited from taking a gun, that's a whole other issue. Into certain areas, he was allowed to have the gun. But I think as a lesson is use it as a very last resort. I think that, whether or not, if you think about it, Mr. Reeves was acquitted, and I think they took into consideration his age, his background, his police training. Given the same facts, someone my age, I may not be acquitted. Okay, so because I'm younger and I may be able to defend myself by other means. So I think if you're a gun owner, just think twice before taking it out, before using it, because if not, you're going to be in a situation where you're going to be facing 25 to life in prison, and you may not get the same results as Mr. Reeves. Because again, as I mentioned, you can walk into any courtroom in any county, and there's shooting cases every single day, and there's a lot of people that are convicted. And self-defense is argued, but not everyone has the same mindset. The jurors don't have the same mindset as the Pasco County jurors, and you may not be in the same physical position or condition, as Mr. Reeves. So I think the key is just use it as a last resort if you're going to use it at all. I'm not a gun owner, so I'm not going to sit there and pretend to know all about gun rights. All I know is it can kill, and a life has been lost over popcorn, over text messaging. That's the bottom line.
Bryant Camareno Law, legal expert for us here at WFLA News Channel 8. Bryant, we always appreciate your time, especially when you come in on, let's say, a Friday night. We know that your time is valuable. Thank you so much for your time, and all the best to you.
And everyone as well, be safe, and thank you very much, sir. Take care.
All righty. Bryant Camareno, folks, back here with you live, everybody, on WFLA Now. As we go through some of the final comments, this is going to be a last call for your #HeyJB questions, comments. We're going to try to go through as many as we can as we wrap up our Curtis Reeves trial coverage. Again, that coverage culminating with 2 words, twice, not guilty. Not guilty for Curtis Reeves on second-degree murder, on aggravated battery. So if you've been screaming or pounding your keyboard to get your voice heard and you really want to have your voice heard, we're going to spend the next 5 to 10 minutes just giving you an opportunity to have your voice heard or to ask a question as we kind of go through some of the final comments here, everybody, on Facebook Live and on YouTube Live. I see that a lot of folks joining us. Let's go over, just check in on YouTube really quickly and say hello to Renee, Lee, Chris Griffin, LN23, Missy Stoll, Katie5 Love, Sandra George, seeing a lot of folks. And I got to be honest, seeing a lot of language I can't put on this particular live stream because there is a lot of angry language. And I think that there are probably more people in our Facebook Live and YouTube Live comment section that are shocked and opposed to this news rather than for it. Perhaps they're just staying here with us in the YouTube Live and Facebook Live comment section because they're just still in disbelief. While if you were of the opinion that Curtis Reeves should be found not guilty, perhaps you have since signed off on this particular live stream and have moved on to the rest of your Friday night. Regardless, we're here with you live on WFLA Now to read through some of your reaction using #HeyJB. Let's see here. looking for some comments. Justin, I can't read that comment. Come on, you know that by now. Liz saying hashtag HeyJB, justice has been served on YouTube Live. I'll come back to YouTube. J Cal, hashtag HeyJB, do you think the prosecution should have had the jury visit the actual crime scene? I don't know. I'm not sure where. That's a very bizarre question. It's up to the prosecutors, the state attorney's office, to present that evidence in a court of law, and to do so through. That's not something that would be something regular or expected to be able to visit the scene. Not to mention too that that's 8 years afterwards, so you can't really visit 8 years afterwards. There would just be so many. You get what I'm saying. I'm going to go back to Facebook Live. Wow. Nancy Lyons saying, and we'll bring up this comment. This is, I'll just bring up this comment and I will allow it to speak for itself. Hashtag HeyJB. What is wrong with Florida jurors? Casey Anthony, George Zimmerman, and now I'm embarrassed to be a Floridian. There are, I think, again, I'm speaking for, there's a lot of folks who are lingering here on Facebook Live and YouTube Live because of this disbelief that is settling in over this. I think there were a lot of folks out there that really thought that this was clear cut and dry, that this was going to be guilty, a swift guilty verdict. And I think that if you're hanging out on this live stream, there's a lot of folks out there that are just still in disbelief. And Nancy commenting and connecting this to other major high-profile cases. I'll say this: I'm not sure that Curtis Reeves is on the same level as Trayvon Martin and George Zimmerman, or of course the Casey Anthony case. Those cases were the international microscope was honed in on Florida in such a massive way. This one, I don't think that the attention was that intense. But Nancy drawing a parallel, and you can agree or disagree with her in the comments section here, folks. Chelsea, I'll bring up this. This is a question. Hashtag HeyJB, how did they come up with a unanimous verdict in 3 hours? Seems like a really short amount of time. Hold on, I want to hit a button. Listen, verdicts can come in after an hour and a half, 2 hours, 3 hours, 4 hours, 3 days. It might seem like a short amount of time, but when you have a jury that is seeing a case from a similar vantage point, these conversations can move along quite quickly. Let's also not forget, no one wants to be here on the weekend. No one wants to have to abide by all of the necessary rules that come with not being able to talk about the case and not being able to be exposed to news media and over the course of a weekend. They did that last weekend. They didn't want to have to do that this weekend. I think that there was probably very much there was this notion of let's talk and come to a verdict. But listen, one of the 6, let's say 5 could have been in unison. One of them could have resulted in a hung jury, and that could have been an extended process. But it would appear that all 6 saw through a similar lens, a similar vantage point, and they came to the conclusion of not guilty. 2 or 3 more here before we have to get going. We've answered this before, but really quickly, Karen, hashtag HeyJB, why only 6 jurors? That's standard in Florida, unless it's a capital case. 12 jurors in a capital case. Go back to YouTube, say hi to YouTube. Liz Morris saying that OJ's verdict came in at about 4 hours. It was 6 people and only 2 counts. That's probably why it was so quick. Yeah, when a jury takes days or an entirety of a day to come up with a verdict, and it can go to 1 a.m, that sticks in your brain more than a case that has a relatively quick verdict. So I think that there are a lot of folks out there that are surprised by how quickly this one came in. But again, you've got 6 that are singing the sort of similar tune as far as how they interpreted the evidence and the testimony. It's not going to take as long as you would think, especially as our commenter just noted that it was 2 counts. So not as complicated, and maybe it was more clear-cut than it was made out to be or believed to be by those out in the public. Let's see here. Barb Olson. I want to bring this one up on screen. Barb Olson joining us on YouTube. Hello to you, Barb. Hope that you're having a good Friday night or Saturday morning. We got folks joining us in the UK and on the western end of Europe here as well. Let's get to this comment. You heard about sympathy coming into play and about Brian Camerano talking about the jurors themselves and being Pasco County jurors who might have seen sympathy with, or might have had sympathy for Curtis Reeves. Barb Olson saying #KJB. I think the jury just didn't want to send an old man to prison. 79 years old. Could this have come into play? We can't say. You just cannot say. The jurors themselves know. And the jurors have the right to tell their story and give their recollection of events and how they interpreted the testimony and evidence presented in this case. But by no means can we sit here and say that this is. But for what it's worth, and I just want to point out something that our commenter is saying, that Barb is wondering if it has to do with the fact of his age, being 79 years old. And let's not forget that if he was convicted of that first charge, you're talking about going away for at least 25 years, maybe. And that's not maybe. It's in all likelihood the remainder of your life. And that would be the most minimum sentence available to you on that charge. So we'll take 1 or 2 more, and then we really got to get going here, folks. Oh, there's Twitter. I'm not seeing too many on Twitter, though. We'll come back to YouTube. Let's see. I'm just giving everybody one last opportunity. No problemo on YouTube says #KJB. Do you agree with the verdict? This is not for me to answer. Our coverage is a reflection of how you feel in our social media comment section. So I always do appreciate there's some very kind-hearted and well-intentioned questions that people ask me. What did you think? You were listening to the case. What did you think of the verdict? And again, this isn't about me. I'm going to remain I'm going to remain professional here and just, again, make this about you and your coverage here, everybody, or make this coverage for you on WFLA Now. Matthew Ehrlich, this is the last one we're going to take. Is Nicole Olson going to speak or expected to speak? Before the trial reached this day, Nicole Olson had informed members of our team here at WFLA that she was going to speak in the aftermath of the verdict being read. I have not seen, but if it is going to be, if there is going to be reaction from Nicole Olson, it'll be on our newscast tonight on WFLA News Channel 8 right here in Tampa Bay. We're going to have coverage from 8 on Your Side's Justin Checker, who's going to be joining us. And you can watch by going to WFLA.com and watching our 11 o'clock newscast. It starts in 35 minutes exactly from right now. So you go to and I'll show you exactly how to do it. You go over to WFLA.com. On the top tab, you'll see video, and you'll see Watch WFLA News Channel 8's newscast. And that starts in 35 minutes at 11 o'clock Eastern time, our television coverage. A lot could happen between now and then, but this is our opportunity to end our streaming coverage here for you folks and send things over to our television coverage on your NBC station in the Tampa Bay area. That is WFLA News Channel 8 on your side. If you want to read the latest on WFLA.com, the WFLA app, if you want additional coverage, you can click on the link in the description on this video. It'll take you over to WFLA.com, the WFLA app, where we have more on Curtis Reeves being found not guilty in the shooting trial. I'm going to head over and spend the next half hour or so speaking with our Instagram audience. On WFLA Now, we are unable to go live directly on Instagram, but there's still a sizable amount of people out there on Instagram who seek coverage. So on my WFLA JB Instagram page, I'm about to go live and talk a little bit more about Curtis Reeves being found not guilty in Pasco County Court. And we'll kind of have a little bit more of a chat going on there. Don't want to alienate that audience. But for those of you joining us on Facebook Live, YouTube Live, you can click on the link in the description on this video. I think it's also in the pinned comment below. It'll take you over to our coverage on WFLA.com, the WFLA app, where we'll also have a live stream of the 11 o'clock newscast with a report from Justin Shecker on all of the reaction from Pasco County in the aftermath of Curtis Reeves, 79 years old, being found not guilty in the Pasco County movie theater shooting trial. Folks, I'm JB Buno. I'm going to head over to Instagram Live in just a couple of minutes. Click on the link for the latest, and thanks for joining us here live on WFLA Now.